All right. How's everybody doing? Welcome to part 2 of Wisconsin versus Geyser release hearing. That was interesting, as always. Thank you for joining us. This is Trial TV Live, and I am the Squeegee of Justice. Appreciate you guys coming back. Let's see. Never a dull moment. Never a dull moment. Just bear with me for a moment while I get the feed up. All right. Mandy, I want to thank you for your 2 cups of coffee. You sent some cups of coffee and a note along with that. So I want to address that. Not here. I just want to thank you for your cups of coffee. Appreciate you, as you know. But I will get back to you on your comments within that. So we received them, and thank you, and we will address that. And we always appreciate you, Mandy, and your presence in our chat. What you have to say is always relevant. They should be coming back around, oh, here, and they are back. All right. Court is back, guys. If you do go Journey to Justice, definitely let us know. You could be our boots on the ground. We'd appreciate hearing somebody from inside. That would be cool.
Can you see and hear us in the media room? Excellent, thanks. Yeah.
To the TV there? Is it okay? No. Stupid question.
I saw a mess.
Really?
But I did.
Right, that's funny.
It's like this big, like, gray chunk of, like,
Cool. So we got Lisa, Portman ready to go. That'll be our last witness. And then the choices for the judge would be to either decide today or you can choose to take it under advisement for a different day. I don't know what you'll choose. Jessica, do you have the next witness on there? Is the next witness on Zoom? Yeah. All right.
I didn't pull it through yet.
Cool.
All rise. Okay, thank you. Please be seated. We'll call a record again on State versus Geyser, same case number and same appearances. We last ended before lunch with the Attorney Cotton being prepared to call an additional witness. And I'm assuming that was Ms. Portman.
Yes.
And so she's prepared to testify at this time?
Yes.
All right, thank you. Ms. Portman, has she been called through?
She's fully connected.
Okay, Miss Lisa Portman, are you with us? Hello, Ms. Portman, are you there? You're muted.
Okay, is that better?
That is terrific. Much better. I can
Okay.
hear you and I can see you. So thank you. Now you're being called as a witness today, so I'm going to ask you to stand, raise your right hand, and our clerk will swear you in. Raise your right hand, the clerk will swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You may be seated. And then if you'd, once you're seated and comfortable, state your full name and spell your last name.
Lisa Portman, Portmann.
All right, thank you, Ms. Portman. Then I'll turn to Attorney Cotton.
Thank you. Good afternoon, Ms. Portman. Thank you for being here.
Hello.
What is your job at, where do you work?
Winnebago Mental Health.
What do you do at Winnebago?
I am a treatment social worker.
What is a treatment social worker?
I am a master's level clinical social worker who provides treatment to patients who are civil and forensic patients at the facility,
So you
both
have,
individually and in group sessions.
okay, so you have a number of patients you work with.
I do.
Are you familiar with Morgan Geyser?
I am.
How are you familiar with her?
She is one of the patients assigned to me for individual therapy.
And so you work with her, is it fair to say that you're her therapist?
I am.
How long have you been providing therapy with Miss Geyser?
I started therapy with her in, I believe, March of 2024.
Does it continue to this day?
It does.
And are you a one-on-one counselor with her, or is this a group setting, or is it both?
I do both.
So Morgan, is this a requirement of hers that as part of her treatment plan at Winnebago, she's required to participate in therapy?
She has a treatment schedule for group therapy, group treatments. That is typically a requirement. Individual therapy is assigned as needed, as desired.
Okay, so as the patient wants to do it, he or she can do it.
Yes.
So since you've been working with Morgan, is she an active participant in group?
Yes.
What is she like?
Morgan is very outgoing in group. She's engaged. She's supportive. She's inquisitive.
How many people are in a group treatment setting? Is it just 2 people, 5, 10, or does it really vary depending on the day?
I would say it varies. At least 4, could be up to 10 or 11.
And are people encouraged to discuss their own personal issues in group? Is that the idea behind it?
Yeah, each group has a different theme, a different direction, a different directive for the group. So different skills that are worked on, and each patient, I would say, is encouraged to apply the information that they're getting or share personally or apply it to themselves to their comfort level.
How long have you been employed at Winnebago?
I've worked at Winnebago since June of 2011.
Okay, so about 13 and a half years there. Okay, and in that whole time you've been employed there, have you been a therapist or a treatment social worker? Has that been your role there?
I've done treatment in my role. The title of treatment social worker started in October of 23. However, treatment has been part of the role. I'd say primarily before the treatment social worker title, I would go with a case management title.
Okay. When you see Morgan in group, does she attend on time?
Yes,
Does she get along with her peers?
yes,
Would you say that she supports her peers, meaning does she provide constructive feedback or thoughts?
yes,
What about completing her assignments? Does Morgan get assignments and complete them?
yes, she does.
What about tense moments that arise in group? Are there ever tense moments in group therapy?
Yes, there are, and she navigates them safely, appropriately, successfully. There's never been any concerns with her.
Do you have any concerns more broadly about Morgan's ability to navigate stressful situations as you've been interacted with her over the last 10, 11 months?
No, I would say she's highly capable of navigating stressful moments that come up quite frequently in the Winnebago environment. So she navigates them, she processes them in individual therapy, and she can compartmentalize what is happening, bring that to therapy, process it, and adjust as needed
When you
if she
work,
feels the need to do so.
thank you, and you provide individual therapy to Morgan as well, so one-on-one.
I do.
Do you feel that Morgan is open with you when you have your one-on-one sessions, or is she more of a hold back, closed down kind of person?
No, she definitely is very, very open. She uses a therapy session really well as a place to open up and process and cope and get information. She really takes full advantage of the individual session to do the work that she needs to, coming to therapy prepared to work, and does her work there.
Do you feel that Morgan is, when you contrast her against other people who are at a mental health facility, do you feel that she's more of an independent person or the opposite of that?
She independently did quite a bit of work and would bring the effects of that to therapy. So I would say independently had the insight to know what she needed to work on, so yes, I would say she's pretty independent and capable.
Have you seen any in the time that you've worked with Morgan, specifically since March of 2024, have you seen any signs of violence by Morgan?
No.
Has she expressed any violent thoughts or ideology to you?
No.
And just so the record is clear, Ms. Geyser has given you permission to speak about her medical treatment that you're providing, okay?
Yes.
So, and I know these individual sessions are private sessions. It's almost akin to a doctor-patient privilege setting, isn't it?
Yes.
And in those private sessions, do you encourage Morgan to open up with you in those private sessions?
Yes.
About any thoughts or fears or concerns that she might have that it's within her head?
Yes.
Has Morgan expressed anything that's raised alarms at all with you during the time that you've treated her, about being violent towards others or self-harming herself?
No.
What about damage to property? Do you, obviously, well, let me take a step back. When you're working with someone in a one-on-one setting, you're listening to what they tell you, but you're also looking at the visual cues that you observe, aren't you?
Yes.
Whether a person is smiling or crying or having a panic attack, you're trained to look for those things, aren't you?
Yes.
And when you work with Morgan in treatment, does it seem that she has do the two of you ever discuss her plans for the future?
Yes, not in specific detail, but just ideology, like what might it look like, or what might be problems she might face, or what resources, where would she go if she ran into struggles, just kind of general information, or extrapolating the experiences at Winnebago and how might we run into this in the future and what might we do. So that type of planning, not specific detailed planning.
Okay. Does Winnebago have conditional release teams?
Yes.
What is a conditional release team?
Well, I would say it's the treatment team in general that she already works with. That's who would be on her conditional release team. That team would connect with the outside team, the team in the state of Wisconsin, who are there to work together, to collaborate, to put together her plan.
So the people who know her best on the inside, the treatment team, will work with the outside resources for conditional release purposes. That's the idea?
Correct, yes.
And you, as somebody who's been employed at Winnebago for going on 14 years, have you been involved in conditional release planning before?
I have.
For clients or patients, if you will?
Yes.
And that's common, isn't it? That you because you work with a person, that you would be assigned to their team to help facilitate community integration.
Correct, yes.
There's been some talk in this hearing, ma'am, about treatment homes or group homes. There are group homes in the state of Wisconsin. Is that fair to say?
Yes.
And is it fair to say that you and Ms. Geyser have discussed, as part of the advanced planning, what that might look like, her living in a group home and her relying on her therapists as future resources?
Yes.
Do you find that Morgan exhibits resistance to the idea of moving into a group home, or does she seem to understand that that's a logical next step?
I believe she understands it's a logical next step.
And hypothetically, if Judge Boren were to approve conditional release, what would you and the conditional release team do once you receive once you receive the green light, so to speak? What would be the next step for you guys?
The next step would be a meeting would be scheduled with her treatment team at Winnebago and the outpatient, the resource, I believe the agency is called WCS. We would schedule a meeting to sit down and discuss what are Morgan's needs, what are Morgan's recommendations, what does she need, what is our opinion of what she needs to be successful in the community. And that would start the conversation, and they would get together and start working on a plan for her.
And when you've been involved in this in other cases, does Winnebago identify the specific group home before conditional release is approved, or do you wait for conditional release to be approved, then you seek out the group home?
Well, we don't actually seek out the group home, the WCS would, and it's not until conditional release is granted that we're able to start that process of planning.
Okay, so once approval is given for conditional release, then you coordinate with WCS and the other resources in the state to make sure there's a suitable facility.
Yes.
And does that get presented to the judge, as you understand it?
Yes.
Okay, so then the judge decides whether or not that it seems suitable in his opinion.
Correct.
Since you've worked with Morgan, strike that 1 minute, please. Just a couple more questions, Ms. Portman. You're aware of the fact that Ms. Geyser sought conditional release 6 to 8 months ago, and are you not?
Yes.
And you were her therapist at that time, right?
Yes.
How did Ms. Geyser process the rejection, if you will, or the denial of her conditional release?
She accepted this is what she has to do. She has to continue to move on. And she brought it to therapy and she held her head up and she continued to move forward and say, I just have to keep doing the next right thing. Really, she handled it very well.
Those are all my questions. Thank you, Ms. Portman.
All right, thank you. Cross-examination.
Ms. Portman, you'd agree that Morgan's very intelligent, correct?
Yes.
And you did not work with her prior to March of 2024?
I may have had her in group sessions. I did not work with her in individual therapy before March of 2024.
That's all. Thank you.
All right, thank you. Any further direct?
No, Your Honor, she's not under subpoena.
All right, then, Ms. Portman, thanks for being here to testify. That'll complete your testimony then, so have a good day.
Thank you.
All right, then we'll end the Zoom contact. Then Attorney Cotton, further witnesses?
No, Your Honor.
Does Ms. Geyser's arrest then?
Yes.
Okay, does the state have any rebuttal evidence or testimony?
No, Judge, no rebuttal.
All right, then all evidence is closed. Everything is in. The exhibits have been received. The exhibits are the CVs and the reports of each of the three doctors. The one item that's been referred to is the November 7, 2024 letter from Ms. Parnell. It's not an exhibit, but it's been referred to, so I have it and I've read it. So it's just clear that what the status of that is. So that means we're at the stage to proceed to argument. How do the parties wish to proceed today? I'm prepared to hear argument this afternoon.
Okay.
So do you need a little bit of time to?
I'm prepared to go forward, Judge.
All right, Attorney Cotton?
Yes, we are too.
All right, well then, let's go forward. And I'll hear from Attorneys Attackowitz. Keeping in mind the state has the burden of proof.
Judge, I guess I'm fairly easily prepared to go forward because...
Could you use your microphone, please?
Sure. Is that better?
It should be, we'll see.
I'm prepared to go forward because preparing my argument was really pretty easy. I have in my hand, Judge, a transcript of your decision the last time we were here, and I have the Randall case. And that's really my argument, Judge. I think in looking at the court's analysis of this back in April of 2024, there's not really anything different here, in my opinion, in terms of how the analysis comes out. And I mentioned the Randall case, obviously, because what is different now, we do have three doctors all saying that you should grant conditional release here, but as the court pointed out last time, and as Randall indicates, the court is not bound by the conclusion that the experts have reached, even if those opinions are uncontroverted. So certainly the court has to make up its own mind as to whether or not the evidence at this point indicates a substantial risk of bodily harm to herself or to others. And last time, Judge, you started your analysis looking at the factors as they're set out in 971.17 sub 4 sub D. And after it indicates the court shall grant the petition unless it finds by clear and convincing evidence the person would pose a significant risk of bodily harm to himself or herself, the statute indicates the court may consider without limitation because of enumeration. Number one, the nature and circumstances of the crime. That's where you started your analysis last time, Judge, and it's the state's position that this offense alone is enough to demonstrate by clear and convincing evidence that there's a substantial risk here to others and to herself. court pointed out that this was a brutal attempted murder. The effort to stab somebody 19 times. But then she's not dead, but then they leave. Of course, with the idea or thinking that she'll bleed to death. You know, when I think about this, Judge, I can't help but thinking most people in society are not capable of committing the offense that Morgan Geyser committed. Most people are not capable of taking a knife and plunging it into someone else. One time, Morgan, as we know, did it 19 times and then left this victim to bleed to death and walked away. So, again, the state's position is the offense alone is enough, Judge, to find that there is a significant risk. I know Dr. Collins indicated that certainly the underlying offense is a factor. I think it has to be a huge factor when you're tasked to consider whether or not she represents a risk of substantial bodily injury. The court then went on to analyze the situation by looking at her mental history and present mental condition. And I think that also is still, Judge, very much up in the air. And I'm not saying it's necessarily up in the air because she's experiencing psychotic symptoms or she's delusional. Those things aren't present. But as the court indicated last time in your decision, Judge, we still don't really know why Morgan Geyser committed this offense. And we've had different reasons provided over the years. The court pointed out the diagnosis initially was, or the rationale was Slender Man. And the diagnosis was schizophrenia. Then we have Morgan indicating at some point that I believe it was shortly before our last hearing in April of 24, sometime in 2023, that she faked all of these hallucinations. Really, as you indicated, really the groundwork for the schizophrenia diagnosis, and she made it up. Then the explanation, I guess, shifts from Slender Man to trauma related from sexual abuse by her father. And the sexual abuse is used, I guess, to go two different routes. One, the trauma from that was such that she lived in this fantasy world, or the trauma was such that she felt her only way out was to commit an offense as horrendous as this and be removed from the situation. We're not really sure which of those two reasons is at play here, but that was the explanation offered. And now, apparently she's backed off the claim that she made this all up. And now, again, I think we're in a position where we really don't understand it. In looking at the doctor's reports regarding this, I guess I would first go to page 4 of Dr. Robbins' report, where he tries to address this and indicates in the middle of the first paragraph on that page, I believe the only reasonable explanation is that either, he uses the word either, so the only reasonable explanation is one of two. He offers two. Again, we don't know which it is, but he offers two, indicating that she did experience psychotic symptoms, or much more likely, her fantasy was so powerful, she came to believe it was real And for multiple reasons, I assume he's talking about afterwards, particularly not wanting to see herself as evil following the events. She had a hard time letting go of it. But it really doesn't offer an explanation about her fantasy being so powerful she came to believe it. I guess that's saying that she really felt that Slender Man was going to get her or her family, and she had to offer up this sacrifice to him. But he also said at the same time it could be that she was experiencing psychotic symptoms.
Now, what page of Dr. Robbins' report are you on?
That is page 4 of Dr. Robbins'
All right.
report, the middle of the paragraph on top.
I see it. Very
Not clear or
good.
sure which one of those it is. I'm sorry?
Yeah, I see it. I see where you're reading from.
Okay. In looking at page 7 of Dr. Lundbaum's report, and this is the last paragraph at the bottom of page 7, in contrast to her previous self-report, Ms. Geyser denied she ever feigned symptoms of psychosis. So now she's saying she didn't make up these symptoms. But Ms. Geyser says, rather, until my late teens, I thought I could make imaginary friends real. They existed in my mind, but they weren't in front of me. When clarifying her previous statement that she feigned psychiatric illness, she acknowledged that it has been difficult to understand her illness and circumstances due to her age when the index offense occurred, and significant changes in her symptoms/experiences over time. That still doesn't give us any explanation, and it goes on to say, while denying that she intentionally fabricated mental health impairments, again, in contrast to what she was saying in 2023, Morgan said, it was easier to say I was pretending. Part of the problem is how young I was. I didn't really understand the severity of what happened until I was about 14. She made further comments suggesting her difficulty discerning fantasy from reality during her adolescence. In combination with periods of dissociation, she acknowledged breaks in her reality attachment. Again, that doesn't offer, and I haven't really seen anything in the doctor's reports that offer an explanation of what she understands now is the reason for her being involved in this offense. In Dr. Collins's report, I guess, on page 31, in the 6th paragraph that begins, in a meeting with social services staff on July 22nd, 2024, in that paragraph, it's stated, he, now referring to Morgan, given the gender situation, he can recall the fantasy life he used, both prior to and since hospitalization, as a way to cope and manage with reality, but has since come to believe that this was not schizophrenia, but rather a coping strategy used to keep him safe from the external threats in the environment. Ms. Geyser acknowledged the use of the fantasy world to conceptualize his experiences following his psychiatric hospitalization. The social worker wrote, he consistently has been using the therapy time appropriately to process and cope with the stressors and questions and pain and grief. He is doing a great job. But again, there's no explanation offered or no understanding or indication that Morgan understands why this offense happened. On page 37 of Dr. Collins's report, in the second paragraph on that page, Dr. Collins indicates, while it is this examiner's opinion to a reasonable degree of professional certainty that facts weigh in favor of Ms. Geyser's petition and placement on conditional release at this juncture, I also recognize considerations which may give pause. The issue of Ms. Geyser's diagnostic enigma is one such consideration. Ms. Geyser now reports that she has never experienced auditory hallucinations or psychotic symptoms otherwise. It certainly seems, Judge, that prior to our hearing in April of 2024, that perhaps Ms. Geyser felt this court may be more inclined to release her if she claimed she had never had these psychotic symptoms, if she indicated she made them all up in an attempt to convince the court that she was never schizophrenic and therefore she's no longer dangerous. Now, this time, and she admitted that she went through with the hearing last time, even though 2 doctors said no, she went through with the hearing because she wanted to know what the court's position was and why the court might think conditional release was not appropriate. And after getting your decision in April of 2024, we now kind of have her going back somewhat and saying, well, yeah, maybe I did have imaginary friends, and I don't see that she ever comes back and says, I lied about making it all up. But she seems to no longer say that she made it all up. She's acknowledging it somewhat. But again, we don't have any clear answers whatsoever, Judge, as to what went on, why she committed this offense. We have, I believe it was Dr. Lundbaum who testified, and maybe it's in all 3 doctors seem to indicate that these doctors all believe that the schizophrenic diagnosis was correct. But it certainly is unusual that someone who is schizophrenic is taken off of antipsychotic medication and any such psychotic symptoms disappear and have not come back. So we really don't have explanations for any of that. It's all still up in the air. And in my opinion, is additional evidence that she represents a danger to herself and others. And I know that was a large part of the court's concern back in April of 2024. The court at various points touched on her credibility, and at page 125 of the transcript, Judge, you indicated the credibility of the reporter is critical to what assessments are made, how people, how professionals, how mental health professionals make decisions. They're critical to how legal people make decisions. The credibility of the reporter is paramount. And I still think there are large questions of credibility here. The other area the court touches on in its analysis relates to the other factors that are listed in 971.17 sub 4 sub D, considerations revolving around where the person will live, how the person will support him or herself, what arrangements are available to ensure access to and the person will take necessary medications and arrangements possible for treatment beyond medication. We've heard a lot about, well, we think a halfway house or a group home is the next logical step. And it was testified to by Ms. Parnell, which I found very interesting, when she said that the Department of Health Services and the Department of Corrections, in my opinion, they have this backwards because it's not consistent with the law. The law lists these things as things the court needs to consider in making a conditional release decision. And Ms. Parnell testified that, well, they don't go through all the paperwork to look at various group homes or placements or provide any of that information at this stage because they don't want to put that work in and have the court deny the petition for conditional release. Well, those are things that the law says you're supposed to require or consider. You can't consider those when they're not willing to put in the work to show the court what a plan might look like, where she might live, where she might work, who she might be with, how they're going to provide treatment. Those are all unknown, much as the court pointed out they were unknowns back in April of 2024. I know, Judge, you touched on the Randall decision last time, and it indicates that making this decision requires a careful balancing of society's interest in protection from harmful conduct against the equity's interest in personal liberty and autonomy. We had questions, I think, to all of the doctors. Well, is staying at Winnebago actually harmful to Morgan? And we heard that, in their opinion, maybe it is, but that's not really a factor that the court has to look at. It's a balancing of society's interest and the community's interest in protection balanced against any interest of the equity in liberty or autonomy. You indicated last time, Judge, that when indicating you were satisfied that Ms. Geyser posed a significant risk, that, and this is on page 126 of the transcript, now she works hard, she continues to do what she's supposed to do, but that doesn't change this risk. The community is concerned to a great extent with what happens to Ms. Geyser, but the primary concern and the balancing in the Randall case, they talk about the balancing that goes on in the court's decision. And you cite to the same section that it's a protection of harmful conduct from society against her interest in personal liberty and autonomy. I think for all of the reasons I've pointed out, Judge, the seriousness, the brutality of this offense, the absence of really understanding, and not only Morgan not understanding why the offense was committed, but everyone else not really being able to gain an understanding as to why this offense was committed, along with the other factors that are just absent in this case, that you should find there's clear and convincing evidence of substantial risk. I know you mentioned right before we took the lunch break, Judge, that there was some statement in the Freeman. We have had conversations with the victim's family. They have indicated they don't wish to address the court, but they wish for us to indicate to you that they are opposed to Morgan's release. That's all I have.
All right, thank you. Then I'll turn to Attorney Cott.
The burden of proof is on the state to show by clear and convincing evidence that the commitment should continue. because Morgan is presently a danger to herself or others. It's their burden. Clear and convincing standard means that the evidence is highly and substantially more likely true than untrue when the court looks at the evidence that the state introduced today at today's hearing. State called as its witness Brooke Lundbaum. That was their only witness to meet their burden of proof. The only evidence they put in was Dr. Lundbaum. And Dr. Lundbaum has a long history with Ms. Geyser. As the court knows, Dr. Lundbaum's history with Ms. Geyser goes all the way back to when she did a competency evaluation very early on in the case before Ms. Geyser was adjudicated NGI. And Dr. Lundbaum, with that very long history, has conducted a number of evaluations and at least 2 conditional release reports, if not more. I think more than that, actually. And last time Dr. Lundbaum testified, the state called her last time as well to meet their burden of proof. She indicated that she did not support release. So what does the state do now in January of 2025? They call Dr. Lundbaum again. And now their witness takes the stand and testifies under oath that based on her deep analysis in this case, understanding the statutory criteria that needs to be considered, she cites it on page 1 of her opinion, the state's own witness testifies in support of conditional release. And I think almost everything Mr. Sapakowicz just said is a red herring to get this court to be scared somehow into doing what I think is the right thing to do and what the doctors believe is the right thing to do. We can never change the crime. It was a horrible event that took place, a horrible act that Ms. Geyser committed, that she recognizes was horrible. She's talked about it at such length with her therapists and counselors. It's been the theme of constant discussion, and we absolutely have no doubt in this history of this case that there were and was psychotic conditions that she exhibited that explains the behavior, no doubt. Now, and that's because there's a confluence of opinions, a unanimity of opinions among all the professionals who evaluated her in close proximity to this offense who agree on that. They agree on it because including Dr. Lundbaum and Collins and Robbins, because they've been a part of Ms. Geyser's life for over 10 years. And all of them agree, and the state's casting a broad brush here, but I think it's far more nuanced than the way they're characterizing it, frankly. We are dealing with childhood schizophrenia, which is, as every doctor has said, both in their reports and testified to at various times, it's a very difficult condition to precisely diagnose. And they did diagnose it, and they identified it. And there's no question that Ms. Geyser, as a result of those delusions and that trauma, committed this horrible crime. No doubt about it. I don't think the state stipulated to that when they agreed to the NGI finding. And it explains the behavior. The question becomes for this court today, when they attempt to meet their burden of proof, the question becomes whether they've shown by clear and convincing evidence that today, as you look at Ms. Geyser sitting here in court as an individual, whether she still presents that same risk today. She doesn't. She doesn't. Their own witness that they called explained why she doesn't. And what Dr. Lundbaum indicates is that the evidence does not continue to support that conclusion that she poses a risk of bodily harm to herself or others if conditionally released. She offers that opinion to a reasonable degree of professional certainty. Dr. Lundbaum notes that Morgan is 22. She comes to the court still committed to the Winnebago Mental Health Institute, and she describes how since 2021, there has been no attempt whatsoever for Ms. Geyser to injure herself. It was the last one and only time that there was any concern regarding her suicide attempt was October of 2021. And Dr. Lundbaum explains this isn't a situation where this is a wishy-washy doctor or somebody who's not confident or hasn't put a lot of thought or effort into their analysis. This is a doctor who explains exactly why she didn't support it in March, but supports it now. She explains that one concern she had back in March was that there was episodic display of heightened emotional distress in the absence of clear provocation or context. And there were concerns about trauma and intrusive memories. What she noted is that since the last petition, Ms. Geyser has been on the minimum security unit at the facility. She's been consistently placed in the pre-integration phase of treatment since June of 2022, which is the highest level of the highest level of permission available. She's earned all the privileges available to Winnebago mental health patients. She's acquired full escorted liberty privileges in February of 2024. She's participated in staff supervised off-grounds activities since March of 2023. And all of the available information, she notes, Dr. Lumbaum notes, reflects that Ms. Geyser has demonstrated, quote, consistent rule compliance. Now contrast that just for a minute against Randall. I don't know the case. It was a big case in Waukesha County, as I understand it.
Well, it's still a big case, actually, across the state. But since we're citing it again, it's at 211 WSAP 102. That's the citation to it from 2011. But go ahead, just to put that in context.
It is a big case.
Yeah.
And what I meant by that remark was that it was a Waukesha County case specifically, as I understand it, historically. That was a very big case for the community, and it remains a published decision, as you know. But contrast what I just read in Ms. Geyser's behavior against Mr. Randall, who, while he was at Winnebago, the court noted, I think it was Judge Dreyfus who presided over the conditional release hearing, noted that while institutionalized, Randall was secretive, lied to staff, breaking rules when it situated him, and his behavior while committed mirrored the behavior that he exhibited in the community. And what Judge Dreyfus noted and the Court of Appeals emphasized in the published opinion that Your Honor cited was that Randall's secretive behavior throughout his years of commitment, throughout all those years that he was at Winnebago, included hiding items above ceiling tiles at a bicycle shop at Winnebago, denying that the items were his. The court noted that that was very similar behavior to what he exhibited during his original crime spree, because as I understand it, he engaged in a crime spree where he hid a CPR dummy above the ceiling tiles of a high school during a burglary. And when Randall was confronted about these things, he would become agitated and angry with the staff. The trial court made other findings about rule violations and inappropriate behavior throughout his time at Winnebago, failing to report to the treatment professionals that he had inherited money in a trailer, purchasing real estate for $42,000 with his inheritance without revealing that, hiding illicit items of property he purchased, receiving mail without the approval of his supervisors, maintaining a secret bank account, only revealing ownership interest in a property 14 months after he purchased it because he believed that he had been cheated out of $70,000, lying about turning over his keys to his property, lying to his supervisors about receiving mail about the property, violating conditions of his off-ground work privileges by going to his property in a restaurant without permission. And he was aware of all these rules. And it was based on those findings that were in the record that the state put in, that the court, that Judge Dreyfus could conclude reasonably that Mr. Randall was being devious, secretive, and essentially deciding he'll do the things he wishes to do regardless of the restrictions or limitations of Winnebago. And Randall himself didn't dispute the fact that he violated the rules on innumerable examples. He just argued they didn't matter. They're not significant enough because they don't involve violence. But what the court noted was you just keep breaking the rules, even when you're in the institution. So I think when you're examining whether they've met their burden of proof and they've called nobody from Winnebago to testify at all that Ms. Geyser has been anything other than an exemplary model patient, and our witnesses substantiate that fact and we don't have a burden of proof. It's far different, far different than the Randall case. Now, there is, of course, the principle in the Randall case that Your Honor cited last time, that if 3 doctors or the multitude of doctors support a particular conclusion, this court is vested with ultimate power and decision-making authority. Nobody's harboring any delusion about that fact, Randall's decision or not. But the question legally is whether they met their burden of proof by clear and convincing evidence. And what you have in this record here is an incredibly thoughtful and thorough opinion by Dr. Lundbaum, where she has examined that history at Winnebago with Ms. Geyser, which has been perfect. We know, and you have in personal knowledge, Your Honor, of Ms. Weier's case, the co-defendant, you have personal knowledge in this situation of what happens in conditional release hearings, not just from that one, but from other cases you've presided over, and you know how the process works. Once the court approves conditional release, the facility will have 60 days to put together the plan with the treatment professionals in the community, WCS and DHS. And they'll put together a plan and they will identify the group home for Ms. Geyser to live in. That's what they do for people who aren't going to go home to their parents. Put them in a group home. And you don't have to approve that. You can reject it. You can look at the plan they put together and say, I don't think a group home that they've identified is suitable, and I don't think these conditions make sense, and you can modify that or reject that as you see fit. But to trigger that process to occur requires you to grant conditional release. That's why this is so important. It's important because Ms. Geyser continues to demonstrate throughout her time at Winnebago consistent adherence to the rules of the facility. And as Dr. Lundbaum is noting, and as every doctor notes, and every person at Winnebago noted, that Ms. Geyser will be placed in a group home and supportive environment. She will be closely supervised by staff as she reintegrates into the community. And as you know from Ms. Weier's case, there will be GPS monitoring. She'll be on a bracelet that will undoubtedly be ordered, and it'll be ordered so that Ms. Geyser's whereabouts are known 24/7. So that was the state's expert. The one witness they called to meet their burden of proof testified contrary to the arguments that they're now making, which is that Ms. Geyser should be essentially indefinitely detained in the facility, because it seems to me that none of these arguments will change. And Ms. Geyser herself has truly maximized the services available to her at Winnebago, and she's shown through her performance that she's not a risk. But it's not just Dr. Lundbaum. It's Dr. Robbins, who's the former director of Mendota, and I don't know who the experts were in the Randall case, but you do have to look at you do consider as part of this analysis who the experts are that are called to testify. There's different levels of doctors and professionals and caregivers in society. Some doctors are new, some are inexperienced, some don't do a thorough job, and then there's others that are immensely qualified. There's a wide range, just like there are of lawyers and other professionals. So last time we were here, 2 of the 3 doctors didn't support release, although Dr. Collins was close. She wanted to see additional positive progress by Ms. Geyser. Dr. Robbins, who was the second witness to testify, is the former director of the Mendota Mental Health Facility. And he evaluated Ms. Geyser, he studied the history, and he also supports release. He concludes that she's not a substantial risk to herself and others based on his study of the history. I think probably I hate to rank witnesses, but I think in terms of the length of the report, Dr. Collins' report was certainly the longest. You have personal familiarity with Dr. Collins in countless cases where she's appeared in front of Your Honor, and you do bring that to the table when you evaluate this situation. You consider your life experiences, you consider your history with Ms. Geyser, with the co-defendant, and also your familiarity with the doctors. Dr. Collins is the gold standard, if you will, of psychological evaluations. She has incredible experience, dozens of years working in this field. She runs behavioral consultants. She's the head of the Wisconsin Forensic Unit. This is a doctor who, by all accounts, I think even the state would agree, the state will frequently use Deborah Collins for its purposes, but Dr. Collins endorses Ms. Geyser's release to conditional release. When you read her report, I don't want to belabor it, but we went through it item by item, Your Honor, and Dr. Collins went through the full history of everything that's happened in this case. She went back through the competency evaluations, she went through the medical records, she read the summaries, she talked to the people at Winnebago, and she reached a conclusion that Ms. Geyser is no longer a substantial risk of violence to herself and others. Part of that is, as Ms. Nicolai pointed out when she called their first witness, there are some tests, the HCR test, for example, that they use to help shape their opinions. But it's also, Dr. Collins' opinion is also the product of her long history with Ms. Geyser, interacting with her, talking to her, working with her. And I thought it was significant that Dr. Collins talked about Ms. Geyser's incredible insight that she has into both why the crime happened, as well as what her needs are in the future. We cited some of it when we were talking to her on the stand. If you give me a minute, Your Honor. When she asked Ms. Geyser about her symptoms and whether there was any malingering, Morgan said unequivocally that she was delusional and thus psychotic years ago. And whether those symptoms were triggered by schizophrenia or trauma, the way you figure that out is exactly how Kayla Pope, the medical director of Winnebago, proposed addressing it. A person is medicated, they've been stable for a sufficient period of time, and we start to wean them off medication to see whether or not the condition has gone into remission or resurfaces. If it resurfaces, resume the medication. If it doesn't, continue on the positive track that we're on. And that's far different than Randall. Far different, because as I recall the decision pointing out, there was a finding by the court that there was no mental health explanation for any of this. And the crimes weren't even attributable to mental illness, unlike here where they are. And he received no treatment. There's a guy who goes to Winnebago for a decade plus and he gets no treatment. And nothing had changed except the passage of time and repeated rule infractions. And that's far different than Ms. Geyser, who went through a battery of treatment, antipsychotic medication for years, and has been willing to participate and has participated in every interview and evaluation that's taken place to determine what her needs are. And you look at Ms. Geyser's continued performance, unlike Randall, you look at Ms. Geyser's performance of working her job at Winnebago, being honest with the treatment providers. You heard from her therapist, who Morgan meets with in a one-on-one private setting. And the therapist described, even in a one-on-one setting, Morgan is highly engaged. She's inquisitive. She asks questions. She works on her assignments. She does the things that she needs to do to better herself. And during the outings that have happened in the community, you have a whole list of infractions by this Randall individual, and the exact opposite with Ms. Geyser. She's going to Target, she's going to Pick and Save, she's going to McDonald's and Starbucks. These are escorted outings, of course, but there's plenty of opportunity. If a person is not functioning properly, plenty of opportunity in these outings for somebody to create a scene, to act out, or to do anything to disrupt the privileges that they have. None of that has happened here. Ms. Geyser's in good, so the question is, the legal question for the court at these hearings is whether the state met its burden of proof with the evidence it introduced today. And it didn't. It didn't, not by a clear and convincing standard or by any standard. The evidence that's come in at this hearing today is that Ms. Geyser is not a substantial risk of presenting great bodily harm to herself or others, or property damage. Even after Your Honor denied her release last time, and she was met with the stark reality of the fact that she was going back into custody, back to Winnebago, and had a minimum 6-month period of time before she could even file a petition. She handled that stressful encounter perfectly. She continued with her therapy, continued with her outings, continued working, and worked on her RAP plan, which also demonstrates her ability to understand her condition. You know, when the state argues that Ms. Geyser there isn't an explanation, there absolutely is an explanation. And in fact, Ms. Geyser herself has developed a wellness recovery action plan that she discussed at great length with Dr. Collins. And Dr. Collins noted, she quoted Ms. Geyser about saying that, I acknowledge and understand the gravity of my past actions. This isn't somebody who doesn't appreciate the wrongfulness of what they did. She does, looking back on it, appreciate that. And she struggled for years to forgive herself for what she did to the, as she put it, the only person who cared about her. And Morgan has completed all of the treatment that's available to her at the institution. There are no greater levels of privileges that she can exhibit. She is a young adult who ought to continue growing in the community. It will make the community safer. It'll make her safer, and it'll make the community safer for her to be out of an institution with acutely mentally ill people so that she can start to grow as an individual. She will be highly restricted, so it's clear. Highly supervised, GPS monitoring, living in a group home. Any misconduct, as you know from your experiences, any misconduct, judge, immediately gets brought back to court. A hold gets placed on her, she goes into custody. If there's even the slightest deviation from the rules and the requirements that are expected of her. But she has shown through her time in Winnebago that she can do everything that is expected of her. She is not behaving violently. She's not injuring herself. She's participating in treatment. She takes her medication. And what Dr. Pope decided to do, I don't know if it's her decision directly or she oversaw it, but the treatment team decision to wean Ms. Geyser off of the medication to see whether the condition was in remission and whether she could be safely supervised without heavy antipsychotropic medication turned out to be the right call, because Ms. Geyser responded favorably to that and continues to respond favorably. Now, do we have 100% certainty? Of course not. That's why the close supervision is important. I would just end by noting that how different this is from the Randall situation in almost every respect. The quality of the doctors that support it, the unanimity of opinions, the thoroughness of the reports, the individual herself sitting here and the things that she's done to prove herself. In the record that's in front of you, the record that the state put in the Randall case showing the pattern of deviousness, dishonesty, deceptiveness that mirrored the crime, justified Judge Dreyfus's decision. No question about it. But this record is devoid of that. Thank you.
All right, thank you, appreciate it. Then Attorney Zipakowicz, do you have a rebuttal argument?
Just briefly, Judge, I don't think this is certainly a determining factor, but it seems to be fairly easily swept under the rug by maybe the doctors and by the defense here. We had this offense occurred in 2014, and we have her suicide attempt 7 years later in 2021. So a long period of time went by between when she engaged in this violent episode towards the victim and then engaged in what I would describe as another violent episode regarding herself, which by all accounts was certainly a very serious attempt to kill herself. There were 7 years in between those two events, and to say, well, this suicide attempt was a long time ago, it was less than 4 years ago. So I don't think that can so easily be considered as being so dated that is not something that the court can consider when assessing whether or not she currently represents a substantial risk. I went back to look at, and I guess I'm unsatisfied, Judge, and I think the court should be as well, from the doctor's explanations of things, because when I look at Dr. Lundbaum's report, and I start at the bottom of page 15 under her analysis and conclusion section, Dr. Lundbaum talks about Dr. Lundbaum's report prior to the hearing in April of 2024, and notes that in that prior report, she raised concerns about Ms. Geyser's remarkably low understanding of her psychiatric illness, especially given her claims that she fabricated psychosis at the time of and for several years after the index offense, in clear contrast to the abundance of evidence available. I noted that the inconsistency in her self-report over time complicated the prediction of her risk for future violence and the ability to create an appropriate supervision and treatment plan. I guess what I'm unsatisfied with, Judge, is there's then no explanation in this current report how that's not still a problem. There's no explanation of how we get past the prior inconsistencies in Morgan's self-reporting and how, over time, that affects the prediction of her risk for future violence. Dr. Lundbaum just kind of skips over that and goes into, well, she's following the rules, she's doing well, hasn't caused a problem, and therefore, because of all that, I believe release is now appropriate. But again, there's no explanation how we get past that prior inconsistencies in her self-reporting. So that's all. Thank you.
All right, thank you, Mr. Sopakowitz. I'm going to take about a half-hour recess just to review items, and we'll come back. Let's plan to come back about 3:15. So we'll be in recess up to that point. Thank you.
All right, so while the judge takes half an hour, because it sounds like he's going to make a ruling today, we'll go over the closing arguments. So let's see, let me go back up here. Okay. All right, so in the state's closing, he recites the last hearing. He says, this offense alone dictates there's a significant risk to herself and others. It was a brutal attempt at offing somebody. Then they leave thinking that she'll bleed to death, meaning what was her name? Payton Leutner. So this was a brutal attempt to off her, and then they meaning Morgan and Anissa, left. So Morgan stabs Payton 19 times, and they leave thinking that she's just going to bleed out. Luckily, Payton survived, so that's a good thing. Most people in society are not capable of committing this offense. Thought that was pretty interesting. Most people don't think about taking a knife and plunging it into someone one time, let alone 15 times. Very fair point. And then they just walked away. The offense alone is a significant risk. Even though delusions are not present, we still don't know why Morgan committed this. So that was his main thing. He just kept saying, okay, Rachel. State said that multiple times. We don't know why Morgan committed this. She just never really says why she committed it. We've heard multiple reasons: Slender Man, schizophrenia. Now, until her late teens, Morgan says, "I thought I could make imaginary friends real." Still, no explanation has been given to this date. No schizophrenia, but a not schizophrenia, but a coping mechanism to cope. Those are my notes. Not quite sure what exactly that means, but a coping mechanism to cope. No explanation or understanding of why this offense happened. So the state was really just kept going on and on about that. She never says, "I lied about making it all up," although he says she somewhat acknowledges it. No clear answers as to what went on and why she did it. Represents a danger to herself and to others, and there are large questions about her credibility. Now, I know a lot of you in the chat were saying that's what you guys thought, and yeah, that was true. There were some things. Well, you know what? I'm going to put up a poll. Let's put up a poll. This is a good time to put up a poll. Let me put it this way. Okay, there's two polls I can, let's see. Well, we'll start with this. All right, so the poll reads, for those that don't know, a poll is coming in: should Morgan be conditionally released? So then the defense comes in and says the state's one witness approved conditional release, and that's what I kept going on and on about. The one and only witness that the state brought in, Dr. Lundum? Brooke, I'll just call her Dr. Brooke. Dr. Lundbaum. She said that Morgan should be conditionally released. And for those of you that are still not sure if Morgan should be conditionally released, please share with us what are you not sure about, and I'll pull those up. And maybe tag it, say not sure, colon, or just so I know, how you voted. So then the defense said it was a horrible act. There's no doubt this was a psychotic episode. Now hold your, let's see. Trial Junkies United says, hold on, let me move myself up here. That is valid from the prosecution point of view. If she can't explain why, then it could be a danger. Childhood schizophrenia is extremely hard to diagnose. This is what the defense was saying. No doubt Morgan committed this. Question for the court: has the state proven that Morgan presents the same level of risk? That's going to be my next question. first I want to get your emotional opinion or what you guys thought, I guess emotionally, or what you thought was presented. And then I want to get your, has the state actually proven that she still presents the same level of risk? So that's going to be my next poll. So so since 2021, no attempts at harm or to harm herself. Nothing but an exemplary patient. The state has not met the burden. She's been weaned off medication. And they see if there's a change, and there hasn't been a change. So she's no longer psychotic or schizophrenic. She handled the stress of the last rejection, which was in April of the last appeal. She handled that pretty well. She understands the gravity of her past actions. And the only person that really cared about her, I guess, was Payton. And she struggled to come to grips with that. So she says Payton is the only person that cared about her. That's pretty messed up to do that to you. The only person that cared about her. She will be highly restricted and highly monitored. So again, she's not just going to be released in the wild on her own reconnaissance. She's going to be highly restricted, GPS monitoring, ankle bracelet, the whole thing. Slightest deviation will put her right back here in the institution. And then the state's rebuttal was her attempt to unalive herself is not so dated. It's only from 2021, so through 4 years, going on 4 years. How do we get past the inconsistencies of Morgan's self-reporting? And Dr. Lundbun skipped over that. All right, so should Morgan be conditionally released? Yes. No. Not sure. All right, so for those that are not sure, let me know. Let me know why you think not sure, because there are 31 votes, 19 of you are still not sure. So let's get to some of those. Who's not sure? And if you don't want to tell me, that's fine. But so Dwayne changed his vote to yes. At first he said not sure. Okay. Special K says, if she has done all the work and has no other place in the hospital, how can she prove she is ready? She has proven that she's ready by going to group therapy, individual therapy, interacting, not acting out, being a normal person, basically. I think that's how she proves she's ready. I think that's how she proves that she's ready, that she's basically a normal person comparatively, compared to the other people there. Yeah, I just wish the victim, I wish Payton had a chance to talk. I just think that's weird that they didn't. I think we cannot downplay the impact of SA from her own father had on her, for sure. Mandy Strong says, absolutely, and I can't even imagine what that would do to a child with a developing brain. Mess it up big time for sure. We don't know how old she was. Was she 3? Was she 5? Was she 10? How old was she? No way to prove it, but her mother acknowledged signs of it having happened. Yep, and said it made sense with what else she knew. Yeah, she said there were red flags. And then they opened up a report on the dad who has passed away. He's no longer there. Little Miss says, I'm sure the facility has done this many times. Yes, they have. I think the last witness, what was her name for the Lisa Portman? I don't have it written down, but I think she's done. I don't want to say how many she's done. She's done a lot. Yeah, everybody's saying she accepted the rejection. So that's another way. What was that one that I pulled up? Special K. She has already done the work and has no other place in the hospital. How can she prove she is ready? Because she wasn't rejected. I mean, she didn't exhibit any signs of her rejection of being released last time. So that's yet another way how she proved that she is ready to be released. I mean, that's a huge rejection. A huge rejection. How would you take that? Again, ask yourself, how would you take that? If you're unwell and you have an illness, you're going to be like, or you're going to act out. You're going to, go inside. Become introverted, act out physically. All kinds of ways you're going to to act out. All right, little miss, you tag me. I'm trying to find it. Where the heck is it? Our little miss says the victims' families didn't want to speak, but said they were opposed to her release. Okay. Dad passed in 2023. Willow Johnson. Morgan accepted the plea. She pled guilty. She got 40 years. Go away. Well, she's trying to get out. We'll see what the judge says. So the sentencing was treatment focused, not punishment. That's true. Did she say why she believed in Slender Man? No. At least not in this hearing. She may have at some point, but not in this hearing. She also did exhibit remorse when she accepted her part of the crime. The attack was premeditated, no question about that. They're not denying it. They're not denying that at all. But what they are saying now is that she has changed her story. First it was Slender Man, then it was schizophrenia. But now she's saying she's grown out of that as her mind has matured. She was, 12, and now she's 14. And now she was 12. So now she's 22 now. So your mind does change chemically, for sure, emotionally. Oh, Mandy Goodwin. I wonder if her father, who was abusing her, was Slender. Huh. That's pretty interesting. Rachel B says psychotic people can premeditate based on psychotic beliefs. Little miss. The other girl was released after 7 years. So that was Anissa Weier. I believe that's how you spell her last name, or pronounce her last name. Yeah, she says she still suffers PTSD and social anxiety disorder. Kerviel, that is true. So Kerviel says, just looked it up. Deborah Collins says she was told that when she was 11. Morgan also claims she was assaulted while in jail. Wow. So Dad did this to her when she was 11, and then a year later she's doing this. Rosebud says Morgan charged first degree, other girls second degree. That is true. Anissa Weier was charged with attempted second degree because she actually wasn't doing the act. She planned it and she held Payton down. But it was Morgan that actually did it. Moki says she's still susceptible to online influences, in my opinion. I believe, and Aaron said that Anissa is not allowed to go online. She is not allowed to go online. No apologies necessary. You were speaking facts. I wasn't aiming that. Okay. Lily Wayne, did Anissa have a smaller role? She held her down, I think. I think she held her down, and I think she came up with the idea. All right, Rachel. See you soon. We're hoping to have Dr. Rachel B. on the show in an hour-ish. So Rachel will get her expert opinion because this is what she does for a living. Yeah, whoop, there it is. Not allowed to go online. Perfect. I'm pretty sure that's what Aaron said. In the group home, they may not allow unsupervised internet use. Yeah, again, even wherever she is, she's going to be monitored. Anissa has a ton of restrictions. Yeah, I mean, they're not just, releasing these people, and they're not just releasing these people into the wild. That's what I'm saying. All right, so Anissa Weier, involved with the stabbing, was granted conditional release from the Winnebago Mental Health Institute in September of 2021. The court imposed several conditions to ensure public safety and support for her reintegration. This is coming from Aaron, who has done some great research here. Living arrangements. Weier is required to reside with her father at a confidential location. GPS monitoring. She must wear a GPS ankle monitor at all times, allowing authorities to track her movements continuously. Internet restrictions. Weier's internet access is limited to her father's home. You know what? Hold on a sec. Let's do this. Let me pull this down. We can read this together. While we wait, let's read this together. Where'd it go? Okay. All right. She was involved in the stabbing. Okay, here we go. Living arrangements. She's required to reside with her father at a confidential location. GPS monitoring. She must wear a GPS ankle monitor at all times, allowing authorities to track her movements continuously. Internet restrictions. Weier's, and I think it's Weier, maybe Weier. I'm going to go with Weier. Her internet access is limited to her father's home, and the Wisconsin Department of Corrections monitors her online activity. She is prohibited from using social media platforms. Okay, so she is allowed to go online, but she can't go on social, and she's being monitored by the Wisconsin DOC. Let me make myself a little bit smaller here. I'll put myself up here. No, let me go smaller. You know what? Hold on. So mental health treatment. Anissa is mandated to participate in regular psychiatric treatment, including therapy sessions and medication management under the supervision of county health workers. Substance prohibitions. Weier is forbidden from consuming alcohol or drugs and is not allowed to enter bars. Weapon restrictions. She cannot possess any weapons. No contact order. Weier is prohibited from having any contact with the victim, Payton Leutner, or her family until 2039. So there you go. That's basically, you don't need a restraining order. She has a restraining order in place. These conditions were designed to facilitate Weier's transition back into society while ensuring community safety and addressing her mental health needs. So the GPS has been lifted, little miss? Okay. So the GPS, she must wear an ankle monitor at all times. Has it completely been lifted or just partially? She could be. Baca, she could be lurking. She could be. Special K, it feels like to me, since all the doctors say that she worked as far as she can in the program, it's worth it for her to go to the next step. The other defendant is free. Yeah. Excuse me. YouTube is considered social. Yes, therapist. So she will not be able to watch us. Widespread panic. I read both the girls said this stabbing was the other girl's idea. Hard to know. Yeah, were they blaming each other? And Loomis says the GPS has been lifted. Crystal H, just trying to have Trial TV Live update their records. What records need to be updated? Oh, so is that her loss? We're awesome. Yeah, look what you could be watching. Oh, the GPS listing. Yes. All right, so just ignore the GPS monitoring chat. Capri Law, if you were her, you'd probably be lurking too. Lurking on our chat. Or lurking, poor Payton. Poor Payton. Payton, we feel sorry for you. Trust me. This was a terrible thing that happened to you, no question. Yes, it came through. Shirley Roth says, if anyone doesn't want to follow their conditions, they will find a way. That is true. They will. They will. But I'm assuming she's got like probation. I mean, she must have to check in. Or I mean, isn't she still, let's see. She's with her dad, but I would assume she still has to go through treatment. I can't imagine that she's just out there willy-nilly doing, just hanging out with her dad and doing stuff. I would think she still has to go, as if she's in a group home, she still has to be on probation, I would think. All right, Curviel. Anissa has been removed from GPS monitoring. Court records indicate a Waukesha County judge signed off on the change to her conditional release September 12th, 2023. Oh, Judge Doro. Yep, Waukesha. Julie says there's absolutely too much freaky stuff on YouTube and hence no YouTube. Crystal H says her dad is has a very strong support for her and is not naive. I would think so after all that he's gone through. Oh wait, Aaron's got some more FYI. Okay. All right, so despite the removal of the GPS monitoring, Weier remains under state supervision and continues to comply with other conditions of her release, including residing with her father, undergoing regular psychiatric treatment, and adhering to internet usage restrictions. Actually, I that's probably not a bad thing that she's restricted from going on social. You know how toxic it can be. She's probably a better human for not going on social, to be quite honest. Well, that's a good one. Wonder if she has curfews. That's a good one. Julie. So Aaron found she's under state supervision, so I would assume she has to check in. She undergoes regular psychiatric treatment, so some kind of therapy. And is not on social. And again, she's probably a better human being for it. So Crystal says judge signed off on the GPS. Okay, wait, Aaron's got some more. Oh, okay, let's pull this up. All right, let me see. All right. Let me get rid of that. Pull up. Where'd it go? Here, hold on, guys. Aaron sent something. Okay, I gotta get rid of that. Nope. Hold on a sec, guys. Bear with me for a moment. I'm trying to pull this up. I don't know why it's doing that. All right, let me interact with it. Yeah. Oh, it's weird. Okay, come on. I'm trying to pull up this People article. Where are they now? All right, that's being a pain in the butt. All right, we're gonna cancel out of that. I'm not sure why it's acting like that, so we're going to go back to this. It's acting as if it's like a PNG. I don't know, Aaron. I'm not quite sure why it's doing that. All right, so let's pull up some more chats. After the attack, the creepypasta wiki, which houses the bulk of SlenderMan lore, was blocked throughout the Waukesha school districts. It's all good. Thanks for finding that, Aaron. Not your fault. Mandy says, I would assume group homes have curfews. Yeah. Yeah, and again, they're not, well, I guess they're allowed to go to work, right? So I think, well, yeah, I don't know. I'm not sure how that all works. Pammy says, the pink banner squeegee had up reminded me of the Devon, oh, yeah. That was number 5, I hope. Moore gave something, yep. Yep. Therapist, who can it be now? Denise Oliver says, I don't believe they should let her go. 10 years for 19 stabs and left to bleed to death. Your opinion. That's fine. We appreciate that. All right, I'm going to end this poll, and I'm going to start a new one. We're going to end this poll now. Let's see where you guys landed with it. Should Morgan be conditionally released? 24% of you said yes. 47% of you said no. And 28% of you are unsure. All right, so the next question is going to be, so I think that's more of like an emotional response. Okay, so now let's start a new poll. Now you have to look at just the evidence. You guys got to take out emotion and just look at the evidence. Okay, so here's the next poll. Now you have to pull the emotion out of it. I know that's kind of difficult sometimes. Pull the emotion out of it and just look at, did the state meet the burden to not allow conditional release of Morgan? I'm sure I could have worded that better, but Widespread Panic says, I'm not convinced she's well enough yet. All right, I'm asking you, did the state meet the burden to keep her, to not allow conditional release? Yes, no, or not sure, and want to order a pizza. Vote away. Chat, vote away. You hit the screen and it pulled you? How can I revote? Can you just revote? Let me see. Can you revote? I don't think so. Sorry, Crystal. I don't think you can revote. Julie, we have no emotions here. Denise Oliver, I know she said 25 surgeries and probably will still have to have more, but they left her there hoping she died. Yes, they did. And she admits that it was a terrible thing, and she does have regret and remorse. Is that enough to let her out? Well, actually, did the state meet the burden? Do you think the state showed enough evidence that she should remain? Or did defense, who brought in 3 experts And the state's own witness said she should be released. I'll leave it at that. The state's own witness said she should be released. The journey to justice. We have group homes here behind my home. Wonder if she may come here. Wow, I think she will be moved out of the county. Wow. That's interesting, journey to justice. Where Aaron and I used to live, there were a lot of halfway homes. There was at least 2. And actually, we had just moved into this place. We had a pretty nice backyard. We were hanging out, and there's fencing, 6-foot wood fencing or whatever. And all of a sudden, some dude just goes running across our yard. And we're just like, okay, climbed the fence, scaled over the fence. And then like 10 minutes later, or 5 minutes later, we heard the cops, and I went out, and I'm like, yeah, somebody just ran across our yard. That wasn't the only time we had helicopters, police helicopters and officers. And there was another guy that they were chasing, and he climbed. He actually broke the fence a little bit. It was interesting where we used to live. It wasn't bad. It wasn't a bad neighborhood by any stretch of the imagination, but there were definitely some things that we saw. The whole block looks like normal housing. Yeah, that's the same with where we were. It was like apartment living, and people were hanging out, Dwayne says, no, the state didn't meet its burden, but what do I know? I told Sharon she forgot to put cheese on my sandwich. She just slapped a slice on my face. Dwayne, that's really funny. That's really funny. Does the city pay for the damage? No, because it wasn't that bad. I mean, it was like, fencing that's like, well, it's like that kind of fencing. No, that would have been our landlord. But no, the city did not. I didn't even think about asking them. How many years of treatment has she had? 10, right? When did this happen? Well, ever since this has happened. This happened in 2014, so 10. Mandy, she's been at this for 10 years. This happened, I don't know the month it happened, or when she got sentenced, per se, but yeah, presumably about 10 years. Willow Johnson, state judge, if it looks like a duck, walks like a duck, quacks like a duck, it be a duck. Yeah, since 2014, so 10 years. 10 years is a long time for someone her age. She basically, well, that's what they were saying. All the witnesses were saying that she has gone through. Oh shoot, they're back. Okay, guys, let me go back on. I don't see the judge yet, but I'll put it back on in case I don't want to miss anything. All right. All the witnesses were saying that, where's the feature chat? All the witnesses were saying that she went through her adolescence, her teenage years, basically. Not basically, she did go through her teenage years in an institution. Oh, Blue Drafts, yeah, any update on the Looney Bird? No, Aaron reached out to them, and they did give an update. That the bird was doing better. They were trying to get it to eat some fish, I think, but that was a while ago. So yeah, I'm not sure. They weren't sure what had happened to the bird, but thank you for asking. I actually had forgotten. Thank you. Dwayne, Sharon says she blames it on the wine. She watched a lot of Miss Boone with me. Dwayne, you're too funny. She slapped you with a piece of cheese. Could have been worse, I guess. Getting slapped, I'd rather get slapped by food than something else. Slap me with cheese anytime. Julie says if she had done everything they have asked her and then some, try it on a trial basis and see how she does. Yeah, that's right. It's not like, if she does anything to step out of line, back in she goes. It's not like, it's not like she's just going to be set free into the wild, Therapist, Looney Bird. No, I'm pretty sure it was the loon. I'm hoping that's what that was referring to. Widespread panic, asked Dwayne, was it intentional? Oh, was it also unintentional? Yes. Pammy says, Julie, yes, I keep going back and forth because I can't leave my emotions out of it, but perhaps it's time for the next step. All right, 6 minutes ago, 33% say yes, 47% say no, and 20% not sure, want to order pizza. Has the state met the burden? Now that's me typing, Pammy, if you're asking. Now, those that aren't sure, is it you're not sure, or is it you want to order pizza? All right. Sorry, Dwayne, we're going to call you out on this one because that was funny. Mandy says, I remember Dwayne falling asleep on his cheeseburger. I think that was around, was that Christmas or was that New Year's? I think it was Christmas. Christmas Eve. Dwayne, you fell asleep on your cheeseburger? I'm sorry, Dwayne. That's just really funny. All right. Dwayne, you're making me laugh so hard I'm crying. I can just see you falling asleep on a cheeseburger. Oh my God, that's so funny. You literally brought me to tears, Dwayne. Or Mandy with that comment. Denise says, she's old enough now, she knows how to play the system. Fair enough, but I would think that those experts, and Dr. Rachel will talk to this, so I hope you stick around for that. She'll be coming on hopefully in about another 40 minutes or so, that these tests are designed so as you to not subvert the system. I don't know how that happens or how that works, but because I would think if you are, devious, you can subvert the system. But Dr. Rachel will talk about that, so please stick around for that. Dwayne, you were sleepy. Interesting captures. Laura, thank you for joining us. New in the chat. I don't recall seeing you, but thank you for joining us. What concerns me in these cases is the fact that they are confined and monitored, so it's easy to say they changed, but that doesn't mean they will be good out of there. Well, there's things in place that as soon as she does anything that's not of the straight and narrow, back in she goes. Thank you for your comment, though. I appreciate it. Journey to Justice. She can't fake it too much. She already lied. Is anybody watching from California? And if so, definitely what is going on out there is insane. I hope it's calming down a little bit. They said the winds might slow down a little bit tomorrow, but oh my God. Oh, well, thank you. Interesting captures. You found us through PI Sam. Very cool. We love Sam. She's a great mod here, and she has her own channel, and we're happy to do work with her, and always happy when she's on with us. Cool. We'll stick around. Yeah, I hear you, Baca. Prayers for California. Oof, that is just brutal. My nephew used to live in L.A., but he got out. He went to Las Vegas, then he's in Peru, then he was in Ohio for a little while. I think he's back in Peru now. I have lost track of him, but I'm pretty sure he's in. Oh, okay. We got a judge. Focus.
The matter is here today after a hearing that lasted most of the day with regard to the petition for supervised release that was filed earlier this year. It was filed on October 11, 2024, and then the doctor's reports were received, and we had each of the doctors testify. So the reports that the court received were from Dr. Collins. With regard to her report, she testified. With regard to Dr. Lundbone, she testified as well as her report. And from Dr. Robbins, who testified, and we have his report. All of the reports were received without objection from any of the parties, and the testimony came in smoothly. What's the nature of I went through at the beginning of the hearing this morning what the status of the initial case is from the standpoint of how it came about back in 2014. We're familiar with that set of facts. What the court has to do today is that the court shall grant the petition for release unless it finds by clear and convincing evidence that the person poses a significant risk of bodily harm to herself or bodily harm to herself or to others, or of serious property damage if released. What that sentence takes into account is that the issues of supervised release and not guilty by reason of mental disease or defect takes into account a lot of cases. That we're dealing with an attempted murder case in this matter, but it takes into account many other cases and outstanding criminal matters that are out there that involve property damage, don't involve people at all. So that's why the statute's phrased the way it is. But our focus is on damage, is on risks of safety to Ms. Geyser herself or the risk to others. And part of that risk is, of course, recidivism, that it happened once, would it happen again, that she'd attempt to kill somebody under any set of circumstances. Those are factors that the court has to look at and decide. Burden is on the state by clear and convincing evidence to establish that the current restrictions and the current commitment should stay in effect. By statute, Ms. Geyser has a right to file for a petition for release every 6 months. So it's not something that, with regard to what the court may or may not do today, if the court denies the petition today, she can come back and file it again in 6 months. That doesn't mean anything other than that. It's just what the law is. Some of it may have been to address constitutional issues with regard to commitments, but it's certainly part of the system. One thing to keep in mind as well, and that this was a serious criminal case, attempted murder. There are 2 defendants in the case. Both were children at the time that it happened, 12 years old. The victim was a child. But the case didn't resolve itself per se in the criminal field. It's not a criminal conviction. In this case, based upon the nature of the law and what happened, the court found that Ms. Geyser was not guilty by reason of mental disease or defect. Then that moves it into the commitment field, the civil field that we're addressing today under Chapter 971, and in particular 971-17 of the Wisconsin statutes. So this isn't about somebody going to prison. It's about somebody being committed to a mental institution, to a hospital, and how that person functions with that institutional setting. In the statute 971-17 sub 4 sub D provides some factors for the court to look at in deciding how best to look at what the issues are. Factors the court can consider are the nature and circumstances of the crime, the person's mental history, Ms. Geyser's mental history, what her present mental condition is. We've had a lot of testimony about that and a lot of reports written on that topic. Where will she live, what the status is, how the person would support herself, what arrangements are available to ensure that she will have access to and take necessary medications, and what arrangements are possible for treatment other than medications. So some of those factors are clearly pertain to the case, some don't. But I'm going to talk about a number of them as I see the reports and what happened in this matter. A further comment for the court to keep in mind, and it was really addresses part of the argument that Attorney Cotton brought forward, and that was the issues in State versus Randall. That was the Court of Appeals decision that was referenced during his argument, and actually referenced by the state at various times as well. In the Randall case, and it's just a 2011 WISAP 102. It's a 2011 Court of Appeals decision. As was noted, Randall is a case that arose out of Waukesha County. It's a Waukesha County case. One of the officers, the wife of one of the officers who was killed, worked here at the courthouse. So it is a case that has deep, if you will, deep roots into the Waukesha County legal system. But it's now somewhat of the stellar case, the keystone case, and looking at issues such as this. But the Attorney Cotton contrasted the conduct of Mr. Randall in all of his situations with Ms. Geyser's conduct, and I think that's a relevant analysis for the court to have heard and for the court to consider. There is a difference between how Randall conducted himself and how Ms. Geyser has conducted herself during the time period that she's been in custody. One of the aspects of the case, and it's apparent, but yet it somewhat needs to be restated, is that the offense in this matter occurred when the defendants and the victim were children. They were 12 years old. The adult offense, no doubt, but still it happened when they were children. It's happened in 2014. It's about, 10 and a half years, a little more than 10 and a half years from the date of the incident. So the victim has grown up, the defendants have grown up, things have changed from the standpoint of the chronology and age of the parties. In cases such as this, we never want to lose contact and forget the victim that's involved. This is a terrible, brutal offense. There's no doubt about it. It's a nasty set of situations. I went back, and at the time that the court made its initial decision of commitment, the parents of both the father and the daughter of the victim wrote letters to the court that described the status, basically, of what was in existence in February of 2018 with regard to their daughter. And those type of factors are still clear today. It's 10 years later, but I'm sure that the impact on the victim, on her family, and on everybody involved in the case is still very apparent and real. So we want to be sure the court keeps that in mind in deciding how best to proceed. There's been a lot of discussion in the case. In fact, it's a critical part of really understanding and analyzing what's happened in the matter, is that the matter was originally came about with the diagnosis of schizophrenia, and that was a lot of discussion at the time of the initial hearings. Childhood schizophrenia is an unusual diagnosis, not common, still not common today, but it still is one that was made and was clarified and established at the time of the hearing. That was the diagnosis that brought about actually the plea of not guilty by reason of mental disease or defect and the court's ultimate findings. There have been changes in from the Ms. Geyser's standpoint and how she's explained what happened. And that comes into whether the Slender Man, the hallucinations and all that went on with that actually happened, or did she make them up? That's been part of the testimony going back to 2021 and 2022. I'm satisfied that those change in views and circumstances existed, but I'm also satisfied that the treating, and I'm talking about the treating doctors, not the examining doctors, that I'm satisfied that the treating doctors have addressed that issue and have worked with her with regard to that. I'm satisfied that the examining doctors, Dr. Collins, Lundbaum, and Robbins, all address those matters as well. And I'm satisfied through the manner in which they've addressed Ms. Geyser's change in position, if you will, or modification of position is something that's can be reasonably explained under the circumstances. I don't find that she was, from the standpoint, attempting to fabricate a position to get a more favorable position with the court. Now, I raised that issue with Dr. Lundbaum as I wanted to hear what she had to say specifically about that. But I'm satisfied that that is not a factor that I'm considering in deciding how to proceed. I am considering that the diagnosis develops over time, as it does with many people, and I accept Dr. Lundbaum's statements that because of the nature of childhood schizophrenia, it's the nature of the diagnosis, the nature of its history, that it would develop and change over time is not unusual. I accept that. I didn't question it was my questions that brought it up with Dr. Lundbaum. I didn't question Dr. Collins or Dr. Robbins about that topic. I was satisfied with what Dr. Lundbaum said with regard to that status, and I'm still satisfied with that. I'm satisfied that one of the interesting, at least I find it interesting and significant with regard to what's gone on in this case and apparently other cases, is that if you're at Winnebago and in a treatment program for a serious offense such as this, Winnebago will only take you so far. And at a certain point, they won't take you any further. Now, it surprised me when this first came up earlier in the case, that I would have thought that the state institution would carry on the treatment and take it to its fullest extent. Whatever the next step is, they would take the next step from the standpoint of improving the mental health of the patient at a minimum, as opposed to public safety, but that's not what they do. At the stage that Ms. Geyser's at, she can't go any further as far as treatment is concerned. And keep in mind that as far as being able to walk around and do stuff, she can walk around at the institution, but if she goes off institution, she always has somebody there. So an escort. Now, to me, in order to be able to really adequately be, if you will, to the extent somebody can be rehabilitated, they have to be able to exist in the community somehow and be able to grow up, if you will. And that isn't going to happen with regard to Ms. Geyser at the Winnebago Mental Health Institute. That's a factor. I don't want to say it's determinative of the decision I've reached, but it's a factor that I've considered as to public safety is really the underlying key to the case, and part of public safety is that Ms. Geyser becomes safe or safer. That was clear in the analysis from the Randall case. It's public safety is tied into the safety of the defendant, of the patient. In Randall, it's clear that Randall never was able, I don't know what his status is currently. He's still in custody. He's still within the program, but that he has he's never developed that sense when people trust him to be safe, and that's the people that treat him. And that was back in 2011. I'm assuming it's still the case today. That's the factor that I looked at in contrasting Ms. Geyser's situation with Mr. Randall's situation. I looked at Ms. Geyser's her role in working through treatment and supervision at Winnebago, and find I'm satisfied she's done what she's supposed to do. She appears to have a good attitude. Attitude is important. It doesn't solve all issues, but it's certainly an important part of being able to be rehabilitated and being able to function within the community. Because although we focus on public safety and whether she continues to be a danger, part of that is if, in theory, she would be released at some point, she has to be able to function within the community on a safe basis, and people, while she may always be subject to some type of notoriety, there she is, that type of thing, like the scarlet letter almost. And but that there has to be, people have to be able to relax and know that if she walks past them on the street that they're safe. That's what the safety evaluation is, the risk to dangerousness is about in the case, as far as I read it, as far as I read what the statute's concerned. That's because, especially with regard to looking at the Randall rationale, Randall stands for the proposition that I can ignore all of the reports and I can find that she's dangerous simply based upon what happened on May 31, 2014, because of the nature of the offense and the nature of what happened. That's, I can make a decision simply upon that. I'm concerned about making a decision simply upon that because it somewhat flies in the face of what the evidence is with regard to Ms. Geyser's treatment program or regimen, and what I'll phrase it as her success at being treated at the Winnebago Mental Health Institute. One of the activities I engaged in when I took the break was to read my decision from April 11, 2024. I had not read it before. Attorneys at Packowitz referenced it, so I thought I should go back and read what I said back then. And my comments with regard to the nature of the case still to a great extent stand true at this point. However, there have been changes in the case and how I view it based upon what's been presented. And I do rely to some extent upon the reports of Drs. Lundholm and Collins. Dr. Robbins writes a good report, but it's a brief report, and it's almost a flow of consciousness of how he views the case based upon his involvement. Drs. Lundholm and Collins go into more, if you will, more depth, more nitty-gritty of what the situation is and how things developed, how attitudes developed, and what the status of the matter is today. So when I read that and read those reports, it gives me a further insight into what the status is of Ms. Geyser's status with regard to the case. What the record shows that she's done well. She's hasn't had rule violations. Laws are always about rules. Lawyers are always about rules. Courts are about rules. And she's followed the rules. She's done well. Good, I mentioned attitude, positive attitude. Those are all good things to have. Does that overcome what happened back in 2014? It may never overcome what happened in 2014. But the question isn't about what happened in 2014. It's about current assessments of dangerousness to herself, to the public, or a danger to the destruction of property. In evaluating the matter, I take into account, as I indicated at the beginning of my decision, that she's been in custody since she was 12 years old. She's gone through a number of evaluations and treatments. Evaluations and treatment that each one of I think both Dr. Lundbohn and Dr. Collins refer to all of the reports that they looked at. That doesn't always count all of the doctor notes that are involved at Winnebago. To a great extent, the November 7, 2024 letter that was signed by Ms. Parnell summarizes all of those medical records and notes and doctors' notes and observations with regard to Ms. Geyser. So I take that into account in deciding how best to approach the case. The aspect of dangerousness is difficult because we never know. I mean, I could claim to be the smartest person in the world and make decisions, and I don't know what's going to happen with regard to this case or many other cases, or what's going to happen tomorrow with regard to my cold. You just simply don't know. So you have to be cognizant of the if you will, the fragileness of the type of decisions that the court makes and that the court looks at. I note that in Dr. Collins' decision, on she wrote a long report, 37 pages, single-spaced paragraphs, so it's easier to read. But on page 37 of her report, in the second paragraph, and I think Attorney Zapakowicz referred to this during his argument, I'm quoting now, while it is this examiner's opinion to a reasonable degree of professional certainty that facts weigh in favor of Ms. Geyser's petition and placement on conditional release at this juncture, I also recognize considerations which may give pause. The issue of Ms. Geyser's diagnosis enigma is one such consideration. Ms. Geyser now reports that she's never experienced auditory hallucinations or psychotic symptoms otherwise. The etiology of her historic psychotic symptoms remains unclear, especially in light of the fact that she has not been prescribed antipsychotic medication in recent years and has nevertheless not evidently demonstrated a reoccurrence of psychotic symptoms. She warrants ongoing close clinical monitoring and treatment, in part to support her transition to the community through, as importantly, to effectively and efficiently determine and respond in the event of any reoccurrence of symptoms of a major mental illness. I read that paragraph in full because that's an important consideration, and it caused the court pause with regard to how to evaluate circumstances. However, when I read the entire report by Dr. Collins and Dr. Lundbohn, as well as what they testified to, I'm satisfied that those are caveats for the court to be concerned with and to evaluate in a way with regard to the issue of dangerousness. It's not necessarily a veto over the release on a supervised release petition. So in reviewing all of the reports and the matters, I'm satisfied that under the circumstances that the great court's going to grant the release. I'm satisfied that by clear and convincing evidence that Under the current set of circumstances, Ms. Geyser does not pose a significant risk of bodily harm to herself or others, or of serious property damage. Now, when I make that finding, I take into account what happened. I take into account the dangerousness of what happened back in 2014. I take into account, though, what's happened since then, in particular in the last 6 months. I take into account the opinions of the doctors, but in particular, and it's been an important analysis for the court to make, that as the Randall decision talks about, that the ultimate determination of dangerousness requires a careful balancing of society's interest in protection from harmful conduct against the acquittee's interest in personal liberty and autonomy. In looking at the Randall case and of what happened in Randall and what the circumstances were of Randall, when I contrast Randall to Geyser, there's a tremendous difference in the rationale for rejecting supervised release in that case, in Randall's case versus in this matter. When I weigh that dangerousness concept and I come back to what happened and what the progress has been, Ms. Geyser doesn't fall into the same category as Mr. Randall in his petition for release and the denial of that release. So on that standpoint, I'll grant the petition so ordered. I'll order that the matter be referred to the department. And let me just look at the statute. 971-17 4E. If the court finds the person is appropriate for the conditional release, the court shall notify the Department of Health Services. The Department of Health Services and the County Department in Waukesha County shall prepare a plan that identifies the treatment and services, if any, that the person will receive in the community. The plan shall address the person's needs, if any, for supervision, medication, community support, residential services, vocational services, and alcohol or other drug abuse. The plan shall be presented to the court for approval within 60 days after the court's finding that the person is appropriate for conditional release. Dr. Lundholm, in her report, and I think it's begins on page 15. That begins on page 16 through 17, lists 11 factors that she'd want considered. And I want those all considered by the department as they determine, excuse me, as they determine what the conditional release plan should be. Excuse me, let me just have a moment. In this area, I took into account Mr. Attorney Zapakowitz's argument about what do we know about the future. Well, the way the statute's set up, as I read it, is that the future is determined by the release plan. We only get to the release plan, excuse me, if the court grants the release. For the reasons stated, I've granted it. I'm satisfied now that the fleshing out of what that means, supervised group home, group facilities, that Dr. Robbins discussed and what Dr. Collins discussed as well, are now subject to the state and further subject to my approval when it comes back. So although I grant the supervised release, I did take into account the argument that Attorney Zapakowitz made with regard to what's known and unknown. I'm satisfied that the system we operate under 971-17, takes that into mind and encompasses it in the in the work that the county, that the department, State Department does with the county. On that basis, then we'll schedule a hearing within 60 days. My anticipation is that the report from the state, the conditional release plan, will be submitted before then.
Right.
So what I'm going to look is to have let's schedule a hearing within 60 days.
How much time do we need for the hearing?
I'd say an hour. We'll just move other things, just fit it in.
February 20th, too soon?
Excuse me, my coughing here. I want to be sure the report comes in. 60 days would take us to about March 9th. That's maybe at the end of February, look to have the report submitted within, say, a month of today, supervised release plan within a month, by the beginning of February 9th or 10th.
I have March 3rd at 9 o'clock.
Should we go for that?
I can make that work. I was going to suggest that Friday that week, if that's available for everybody, but I can be flexible.
The 3rd is good for me, better than the 6th or 7th.
Okay, let's just do the 3rd in the morning.
Attorney Nicolai?
That's fine. The 3rd is fine.
Okay, 9 o'clock?
Sure.
March 3rd at 9 o'clock.
Oh, so I'm anticipating that we'd have the proposed conditional release plan by, I'll say by February 14th. Now that may change. The state will do what they have to do, but I want to be sure we have plenty of time to evaluate it. With that, then, Ms. Geyser will be remanded to the sheriff to be returned to the Winnebago Mental Health Institute.
Thank you.
So ordered.
I'll be in touch.
Court will be in recess.
All right. That concludes Wisconsin versus Morgan Geyser. Pretty interesting. All right, stick around because Dr. Rachel's going to be joining us. She had an appointment from 4 to 5, so she'll be joining us hopefully in a few minutes. I'm going to just take a quick break, meaning I'm just going to get some more water, and but stick around. We'll answer all your questions. All right, don't go anywhere, chat. Oh, wait, let me see the... All right, so the judge's verdict. So this was filed October 11th, 2024. So the last one was April. So April, May, June, July, August, September, October. So every 6 months, right? So clear and convincing evidence Morgan offers serious harm to others or herself. So did the state prove that? Focuses on risk to Morgan or to others. It happened once, it can happen again. By statute, Morgan can petition for release every 6 months. This was a serious attempt to off somebody. Everyone was a child. But it wasn't a criminal conviction. It was not guilty by reason of insanity, so it moves to a civil field. It's not about someone going to prison. It's about someone going to an institution, how they act there. So the factors the court can consider are mental history, past environment, how will she support herself, access to meds, other treatments other than meds. Then he cites the Randall case, which was from 2011, and the Court of Appeals decision. I guess this guy shot a Waukesha county officer. So he said it has deep roots there, understandably so. But he says that's now a keystone case in looking at issues such as this. I guess he tried to get out, and they said no to him, I guess because of how he acted. The defense contrasted Randall to Morgan's conduct. The offense occurred when they were 12, adult offense, but they were still children. The victim and the defendants have both grown up. And you never want to lose sight and forget the victim. So, yes, Payton, we will never, ever forget you. You definitely have a big story in this as well, obviously. And the impact on the victim's family is very real, and the court wants to keep that in mind. And this surprised us, and in the chat, it surprised the judge too, that Winnebago can only go so far. A state institution can only go so far. So he compared Randall to Morgan, and it was all about public safety. So will Morgan be able to go out into the public and not be a threat, a risk? Randall apparently was not able to do that. He says good attitude is important. Medical records and notes are all taken into consideration in deciding. In reviewing all the reports, satisfied Morgan doesn't pose a risk to herself or others, and with that, he granted the release. He again cites the Randall case. Matter to refer to the department, 60 days to review the plan. That's when the judge hacks up a lung. February 14th needs conditional release plan, and then he remands her to the Mental Health Institute. So with that, has the state met the burden to release Morgan? 32% of you said yes, 46% of you said no, 20% of you said not sure yet, but you want to order pizza, and Special K and Valeria Carayulo, sorry, I butchered your last name there, Valeria and Special K wanted to change their votes to order a pizza. So, all right, so on that, I'm going to go grab myself a quick glass of water. Rachel will be joining us shortly. Oh, and she's there. All right, Rachel, hang on just a second. I'm just going to go grab some water. Hang on. Okay, chat, just give us a second here. Get the link. Is this the link? Mm-hmm. Copy. Yep. Properties. Okay. Can you hear me, Rachel?
I can. Can people see me right now?
Okay, hold on.
Or can you hear me?
Let's see. All right, I cannot hear you.
Try unplugging your earbuds. Try unplugging that and just see if that works.
Okay, go ahead and talk for a second, Rachel.
Hello? Hello?
Okay.
Hello?
All right.
Oh,
Can
now
you
I'm
hear?
echoing.
You're echoing, probably because of my mic. All
Oh.
right, that's why I need the headphones in. All right, bear with us, chat.
Can you mute?
Oh, they can see me now.
Yeah.
Okay. Can you hear me, Rachel?
I can hear you. Can you hear
Okay.
me?
Joys of OBS versus StreamYard. All right, let's try this again. StreamYard is so much different, so much easier. All right, I'm going to play with some settings. Hold on a sec. Let's just get this audio sorted out. So, Rachel,
Okay.
can you hear me?
I can hear you.
You can hear me. Okay, I cannot hear you. So hold on a sec.
Okay.
Okay, Rachel, can you hear me?
Yes.
Okay, I cannot hear you. Okay, Rachel, can you hear me? Shoot, I still can't hear you. Dang it! All right, hold on a sec. Let me try something. Okay. Oh, wait. Go ahead. Go ahead, talk. Okay. I can hear you. All right, hold on a sec. Okay, I can hear you now. Hold on. Let me do. Okay, keep talking.
I was gonna answer OnlyFans question. The plug for the shampoo I use is Virtue Labs. It is Jennifer Gardner. Jennifer Gardner is the spokesperson. I have a lot of hair, and I love my shampoo, so highly recommend. Thank you. Thank you. I don't, but I'm not listening to. Oh no. Oh no. Okay. Okay.
Okay, go ahead and talk, Rachel.
Hello.
Yes.
Testing.
Okay,
Hello?
sorted it out. All right.
Wait, someone just said I can't hear.
I hear
Kristen.
both. Now we
Okay,
can't hear
I don't care.
Squeegee. Okay.
No, but it's
can't hear me.
delayed. I think on YouTube though it's delayed, like what they're hearing.
Yeah.
So maybe
Maybe
they can
delay.
hear us
All right. Muted Chris. Now I can hear SlenderMan. I can hear him now, but can muted. I'm muted.
now.
All right. Okay. Now you hear
And-
both.
okay.
Okay. There we go. I hear both. Yay. Okay. Okay. All right. Yeah, I was playing with some features, monitors on, monitors off, but now everybody can hear. Okay. Everybody can hear us both. Yay! All right, now let's sort out. Now hold on. Now let's sort this out. Now that we got that, let's make you a little bit bigger. And
I'm getting texts from Erin like, can you hear him? Can you hear him? Yes, I can hear him. I can hear both. Like I haven't even responded
all
to
right,
her.
we'll go with that. Make us even. All right. Is the background okay, you guys, or do you want? Should I just do a black background? Let's just do a black background.
Yeah, a creepy guy in between us.
Right. All right. Let's just do that.
This is so funny.
No, it's cool. There. All right. Let's just do that. Okay. Yay! All right.
Okay, so
Good.
so quick. Wait, on this platform, like I can't see the chat, right? So like you're gonna have to tell me
Oh, I can pull it up,
what's happening.
right? I can pull it up here.
All I see is you and me.
That's fine. Is that cool? Do you see a comment that I just pulled up?
No.
Can you open up YouTube?
Yeah, let me do that. Hold on.
Go to
it's delayed
Yeah.
on YouTube, but guys, thanks for being patient. You're awesome.
Yes. Yeah, there's a delay for sure. What happens on YouTube is about 10 to 15 seconds behind, but at least you can see the chat, and then I'll pull up. If you see something, then I'll pull it up. Like right now, I had a little miss.
This is so funny. These are my texts from.
All right.
Okay, mute the audio. Okay, I can do that. I muted
Therapist,
the audio.
Okay. Yeah, mute the audio for sure. And it's just for you to look at the chat. And then if you see something you want me to pull it up, then I'll pull it up.
Okay.
All right.
Woo!
Okay, so
What's up, everybody?
welcome, Dr. Rachel B. in the house. Do you want to introduce yourself for those that may not know you? Although I can't imagine nobody knows her. Nobody knows who you are, or anybody knows who you are. What if that? I'm just going to shut up. Please introduce yourself. Oh no! We just lost her. Wait, hold on. Are you kidding me? Nope, there, you're back. Okay. You're back. You're back. You're back.
Oh.
You're back. You're back.
I didn't know I left, but okay, I got this. I got
Okay.
this.
All right.
Okay.
Hang tight.
Ready?
Okay. Please introduce yourself, Dr. Rachel.
Hello, everyone. I'm Dr. Rachel. I am a clinical and forensic psychologist and moderator for Trial TV Live, and love it here. You guys are awesome. I think we all need a drink and to laugh. So hopefully we'll do some of that along with talking about everything today. I didn't think this hearing was going to be an all-day thing.
I had no idea how long it was going to last. If it was going to be 2 hours, 3 hours, all day. So thank you for being with us and then being on the show. Really appreciate that. So what jumped out at you? Like, where do you want to start? Like, what jumped out at you? I know there was a lot of questions in the chat. You were responding to that. What were your first impressions? And then we can kind of take it from there.
Sure. So I watched the last hearing that she had. And so what I knew from that was that Morgan had come out saying, no, I've been faking the whole time. And her treatment providers were like, okay, whoa. Mm-hmm. First of all, we've known you now for, almost 10 years, and we've seen you. Like, you can't fake this for 10 years, like, especially with her age. And I mean, it exhausts me even to think of trying to fake being psychotic consistently, even for 24 hours. Like, that would be so much work all the time. There's just no way you can fake it.
Yeah.
So regardless of what her diagnosis was or ended up being, or her symptoms or whatever, there is no way that she duped all of these treatment providers over time. There's no way. Mm-hmm. I'm telling you, that is a fact. It is not an opinion. That is a fact. So that, I thought, though, pointed out to her treatment providers a gap in the treatment that she had been receiving. Like, whoa, wait a second. Like, with her saying this now, it's very clear to us, like, she doesn't understand her diagnosis. She doesn't understand, like, the severity of her illness, perhaps. She doesn't, like, this is something we need to work on and be sure that she understands, like, what to recognize if she's decompensating, what, she doesn't have to fully understand what was going on when she was 12. But now at this point in time, she needs to be able, she can't go out into the community and think, I was never mentally ill, because then that leads to, I don't need treatment. I don't need to take these medications. I don't need this group home, this. So I almost think it was beneficial in the end for them to discover this. Mm-hmm. And for her to make those claims, because then they were able then to go back and address with her, like, whoa, where did that come from and what is going on? Mm-hmm. And, from April until now, that's a significant portion of time to be working on something like that. So I don't think it was a situation where she like, learned that that wasn't going to fly and now she knows what to say. Again, it would still be very hard for her to pull all of that off for that long period of time. So now hearing, and I really liked the psychologist that spoke at the April hearing and spoke again today, the dark hair lady with the dark hair. What was her name?
The very last one, yeah, the last doctor. Let's see. She was
the one who said last time that we needed to see more stress on her. We
Yep.
needed to see like how she copes.
Deborah Collins,
Yes,
Deborah
I really
Collins.
liked her.
clinical
liked how
psychologist.
thorough.
Yeah.
Yes,
Yeah.
I liked how thorough she was. I liked her ideas about how, we really don't know how she handles stress yet. Like, we need to push her a little bit harder, work longer hours. We need her to, I liked that she really took into consideration those real world things. And so for me to see her now changing her opinion about the release, I really trust her. Because she pointed some things out at the last hearing that other therapists did not. I felt like she had a really good grasp on what she needed. So also, I thought it might be helpful to talk about, like, in the hospital she's in, I don't know that specific hospital, but when they talk about the step down process for like least restrictive environments, maybe it's helpful to understand like the progression that she's likely gone through at the hospital. Because they talked today a lot about her having like all the privileges she can have, all of that kind of stuff. Is it okay? Can we talk about that?
I think so, yeah. Why not?
Okay, all right.
Yeah.
I just didn't want to like impose if you had like a specific way you wanted to do things.
No,
Okay.
not at all.
So
Yeah.
at the hospital, when she first got there, this is not 100%. This is typical forensic state hospital stuff here. She went first to a locked unit. So you don't leave the unit, you don't leave it supervised, you don't leave it unsupervised. It's a locked unit. And you eat all your meals there, that's where you sleep, that's where your programming is and everything, where your treatment team meetings are. Don't go to the community. And you're monitored there, stabilized on medications for as long as you need to before they decide, okay, well, like, this can be and they have usually have like psych techs outside of every single room. It's almost literally a one-on-one, like visually one-on-one, not just cameras, but like person watching you at all times.
Okay.
Except when you're showering or using the bathroom. But like,
Right.
You are never alone, basically. Then the next step down would be something where you might be able to go to different buildings within the facility itself that is also locked. You might be supervised. You might be able to go to a treatment room that's in another building for a specific group. You might get more free time out in the yard or whatever. You might earn cigarette privileges. You might be able to go to the library supervised to go pick out a book to bring back, that kind of thing. But you're always still under very specific watch. There's also like more activities they'd open up with supplies that you might not get in a locked unit, because people who they think might be an imminent risk to themselves or others are not going to be given like pencils and scissors and that kind of stuff to do activities with.
Sure.
So it probably opens up a little bit more for that. And then sometimes there's other steps in between, but ultimately I'll give the example of where I worked was at Trenton Psychiatric Hospital. They had cabins. So in one part of the hospital, it was like group homes. There's like 12 group homes all in this like semicircle, and each is fully staffed with medical staff, mental health, nursing, and psych techs too. And everyone who lives there is responsible for taking care of the home, helping to cook meals. They occasionally, like, whoever gets privileges gets to go out supervised to the grocery store, get what they want for dinner, bring it back, they cook. Like, it's life skills, right? And these are people who are low threat level. They might get jobs within the facility. They're less supervised. They get escorted from one building to another building, but within the building, they may be able to do their job or do whatever. And that's to help them transition, because some of these people, like her, who have been there for 8, 9, 10 years, you can't go from a locked facility out into the world, even out into the world in a group home.
Yeah.
Like, you need some kind of transition of, hey, this is what a group home will look like when you do go to one. But it's within the confines where you have, you know, a little bit more support. So I think when she leaves there, it's going to be very similar to what she's already experiencing, except that, like, if something were to happen, like, it's just the greater hospital is locked, right? So, like, you can't get to the exit and get out. You know, you can't leave the cottages and just go out on the street because the entire grounds are locked. So that's really the difference. She's going to be in a group home, escorted places, like to the store. They're not going to be like, oh, okay, well, here's your driver's license, go wherever you want.
Right.
It'll be highly supervised. She's going to have sort of like court officers to meet with. She's going to have therapy. This plan that they come up with is going to be very specific of what is required of her in terms of how many times she sees what treatment provider a week, how many groups she's to participate in, what her behavior is to be, who she's allowed to have contact with or not, if she's allowed to be on the internet or not. It's going to have a lot of detail in it. And if she violates any of those, she's going back to the hospital.
Right.
So, like, they're not going to allow her to miss a therapy appointment unless she is, like, throwing up or something. You know what I'm saying? Like, it is.
Sure.
Yeah, it's going to be really strict.
I have so many questions and thoughts and comments. So let me see if I can remember half of them. So she has proven, Morgan has proven while she's been in this institution that she has the ability to go supervised to the library off the grounds, to go to a Starbucks. They brought up Starbucks a couple of times. So kind of walk us through that. Like, what did she have to do to gain that trust? And then is it physically somebody just right there with her, walking with her? And if she tries to bolt, what do? Do they stun gun her? Like, how do you stop somebody if they want to bolt? Like, not that would happen, but if that did happen, like what are her restrictions, if you will?
Sure. So I'm assuming, because most hospitals have, it's like a risk assessment checklist, and you have to score under a certain amount to be allowed these privileges. So as far as like violent acts, breaking of rules, and the rules are like similar to jail. You can't trade food, you can't sneak off with other people, you can't backtalk a provider, you can't, so she's, think of it as like, she hasn't been written up, essentially.
Gotcha.
And so, those, if any of those things happen, you accumulate points. And those are all like defiant behaviors, increased risk for taking you out somewhere, right? So if you're breaking the rules, like, you're not going to be taken off grounds because you'll break the rules out there. So it's really all about risk and compliance. Symptom management, like how severe are their symptoms right now? What does that mean? So she must have been deemed low enough risk to be able to go out. So I imagine I don't know if she got taken out individually or in groups. It may have been individual. Some hospitals, it's not like a security officer that takes her out. It's not like an officer. It would be a therapist or like a social worker that would take her out.
Sure.
And
she's going to pass. Like, I'm sorry, you said she's going to pass all these risk factors before they even consider letting her out or letting her go on these trips, if you will. Yeah. So.
All right. I have to throw things every once in a while to make a noise to make my dog stop barking. Okay. They've already determined her low enough risk to be trusted to go out and do these things. Yeah. Right. So.
All right. So we do have a couple questions which I think are very valid. We'll start with OnlyFans says, how do they regulate the internet use?
Oh, that's a good question. Well, I don't know if the I don't know, because they're doing that for Anissa too. So I guess it must be. Gosh, I don't know how you would regulate that. And that might be like an honor code thing. If they end up finding her somewhere on the internet, then she's going back to jail kind of thing. I don't really know. In the group home, they probably don't allow them internet access anyway, unless it's supervised. And I'm sure there's like passcodes that only staff have to be able to get on the internet.
Yeah.
She's certainly not going to have a smartphone that has internet access.
Right. Well, isn't it like child controls that you have? I've never used it, but I think there's like I'm sorry, parental controls that you can restrict your child what they're going to see, what websites they're going to go to, or what websites they can go to versus what they can't go to, that kind of thing. So I've never done that, but I've read about it and I've heard about that. So maybe it's kind of the same thing with her.
It could be restriction, to social media, and also to like be able to look people up. Like they're not gonna. She's probably gonna have a no contact order still with the victim and the victim's family and all of that, and so she'd be restricted from websites where she could try and contact.
Yeah. Cool.
Someone else.
Now, Pammy has a great question. Hypothetically, if she does mess up, I'm wondering the method they will handle it. That is, 3 strikes you're out, or so many in a time frame. Just one and done.
No, it's going to be one. I mean, it's going to be like you skipped therapy and you're not really sick. You're going back.
Right.
Like she is not going to be allowed to miss any treatment appointments.
Okay. So even the level of severity, it's like whatever you do outside of what you're supposed to do, that's it. There's no excuses. You can't, unless you said like you're sick.
Correct.
If she's sick, that's one thing, of course, and everybody will know that. But if she's if she just decides not to show up, even just that, or what if she's late? What if she's running late? Is that like what if she's running 5 minutes late?
No, I think so. It's going to be up to the group home to report her, right? And so like they're going to use their discretion regardless. But I'm sure if she's late, if there's a good reason for it, it's not going to be like that. Like if they know where she was and she ends up being late, they're not, because she's in the group home and like is late because she was using the bathroom or something, you know what I mean? Like, no, it's not going to be like that.
Right.
But like if she refuses to take her medication, I imagine that day that she refuses, they're having a treatment team meeting with her to determine what's going on and what her attitude is about it and that kind of thing. So it's going to be really strict. Like she cannot mess up and she cannot deny treatment.
Right. Gotcha.
Yeah.
Let's see, just going through if there's any other questions before I go back to mine. Okay. Aaron says they probably put governors on the sites she can access.
Oh, I don't know what that means.
Yes.
But okay, yeah.
Aaron
You
does.
techies. You techies. Can you guys hear the dog? Is that really annoying?
A little bit. It's not so bad to me. Journey to Justice, Wisconsin Department of Corrections monitor her online activities. So is that literally somebody watching?
Oh.
So they have somebody. Do you know anything about that where you are? I mean, is that literally they pay somebody?
And I worked in these facilities before that, but like how could they monitor just her activity? Like they'd have to know what, because like if she goes to the library and gets on a computer there versus if they have one at the group home versus they go to a coffee shop and they have one, like I don't know how they would monitor just her.
I don't know either. That seems like a nightmare.
Different IP addresses.
Yeah, for sure. But my God, that just seems crazy. All right, so let me go back to some of my. I didn't write questions down. I was just like taking notes of what was being said. But there definitely questions came about. So do you? So what do you make of her changing her story, if you will, from it was Slender Man and then schizophrenia and then PTSD? What do you make from her? Did she change her? I mean, let's start there. Do you think she changed her story?
Yeah. I think when I look at this and conceptualize it, I mean, I think it'd be very hard from age 12 on. And she is in constant treatment, learning about herself, learning about what's going on. I mean, it would be very hard for her. I think it's probably only recently, and maybe even still, her being able to integrate all of these parts that came together for this perfect storm in order for this to happen. I mean, I think it seems to me anyway that the Slender Man situation was a product of psychosis, a product of this distorted thinking. So like it was him, but it also was psychosis. So those two things are kind of the same thing. It's not a different story. Maybe she couldn't conceptualize that those two things were connected before, if that makes sense. And now she understands that.
Yeah.
Yeah.
And then she also, I'm going to pull up Baca's question, and then I'll ask my question. How long will the group home status be for? That's probably undetermined at this point, right?
Well, so the judge wants reviews still, right? And
Yeah.
so, yeah, that's undetermined. That's for as long as they think that she needs it. I imagine the group home has different steps. Like first, she's just there and getting adjusted,
Right.
seeing how if she attends her appointment, like how all of that's going. They're going to probably encourage her to figure out education, figure out, is she going to work? Is she going to, what that's going to look like? That's going to be a while though. Like she'll be very supervised for a long time.
Now, will this also be an opportunity for her at some point to appeal to get out of the group home status, like they were saying, a transition to an apartment living on her own, like say 5 years, 10 years, whatever that time frame may be? Do you know, like in the institution, she's allowed to appeal it every 6 months. Do you know how long?
Yeah.
I know you can't answer this because it's like you just can't because we don't know. But at some point, she will be allowed to say, "Hey, I've met all my requirements. I'm on a good path. I want to transition into individualized living."
Yeah.
So at some point, she will be able to do that. I would think, right?
So I don't know exactly how that works with it being the 40 years of monitoring.
Okay.
Possibly. So like in the group home she goes to immediately will be like way more restrictive. And I imagine that eventually she will move to a group home that's a little less restrictive because she needs like, if she's going to go to school, if she's going to get a job, like, but then she would still come back to that supportive environment. And I think that's going to be many years of her like transitioning through various levels of group homes and transitional housing. And then I would imagine eventually, because it'll still be within that 40 years, I mean, I imagine there are teams called assertive community treatment teams, and they are mental health related for people with severe mental illness. So you can get your own apartment or roommate or whatever, work, do whatever, but they come out to your house to make sure you're taking your medications every day. They, they're very involved with you, but they come out to you in the community. And so you could have your own place and you don't have to like live in a group home anymore, but there's someone checking in on you all the time. So I imagine that's what that will look like for her for a very, very long time.
So she still has to serve her 40 years, is what I'm hearing from you.
I think so. Like, I think the 40 years is like under supervision for 40 years. It just doesn't have to be in the hospital.
Right. And yes, Little Miss,
my impression.
DHS is definitely going to be involved. Let's see, let's see, who talked about that? Dr. Collins, I believe, talked about that, the woman that you liked, the doctor that you liked. Or no, was it? No, it was actually Jennifer Parnell, who was her psychiatric provider. Once conditional release is granted, a team of DHS, social workers, therapists meet weekly to establish a plan of care as to where Morgan will go, supervise group home, and then the care she will receive. So yeah, it's pretty comprehensive for sure.
The dogs will stop in a second. Everyone just got home, so I apologize.
Okay. All right. And beautiful waterfalls. She did, but it wasn't. Well, Rachel, I'll let you take this one. What did she express?
What is it?
Did she express remorse? Did she ever express remorse?
Yeah, her treatment providers or the people that wrote reports did indicate in there the comments that she made about remorse and wishing this had never happened and understanding her role in the crime and it being her fault. Like, I don't know that she ever spoke in court on her own, but her statements to the treatment providers, they did talk about that today, that there was some communication of remorse. Yeah,
she understands the gravity of her past actions, and this is what I found interesting. The only person that cared about me was Payton. I want to say Tyler was Payton.
Yeah.
So the only person that she feels cared about her was Payton, and yet she did this horrific act to her. So I thought that was interesting.
She was very disturbed.
Yeah.
Yeah, I mean, she was very disturbed.
She said she struggles. She struggled with coming to terms with it. So she didn't. I guess what we're looking for, Chad, is like, I'm so sorry I did this. I throw myself on the mercy of the court. No, she didn't do that, I guess, but she did, in essence, do that to her providers and her therapists, that she was remorseful, but we didn't actually get to witness that, I guess.
No.
So,
but I think that her consistent and participation in her treatment and how much work it sounds like she really did put in,
Mm-hmm.
which is kind of rare, honestly. I mean, I think that speaks volumes as to her understanding that, like, I need help. I did this. It was horrible, you know, and
Yeah.
realizing, like, this is a big deal.
See, I wish Chloe Driver had that same opportunity. I really wish she was
Yeah.
where Morgan is, because I think Chloe needs this kind of help. She needs this help desperately. I want to ask you, because earlier you said something about 6 months is a lot of time to do work. Is she in therapy every day for hours?
Yes.
So it's like hyper focused. It's not like she goes once a week for an hour. She is like literally every day, probably for 4 or 5 hours, doing certain individual or longer. So 6 months is pretty.
There's free
intense.
time.
Yeah.
But yeah, there's, especially like in the cabins or in the more independent area, there is free time and they have chores and they have responsibilities, but there are every single day, there are groups and there is therapy every single day.
Mm-hmm.
The one social worker talked about how, like, she can come when she wants to, kind of a thing, but I felt like that person was more of a not like her main therapist. She was like somebody else. But yeah, I mean, she's checked in on every single day.
Yeah.
And definitely involved in groups. And that's why they're like, you know, at this point, she's like done every group, you know, like she's going to get bored. Like she can't learn any more here.
Right. I thought that was pretty insightful. I never thought that, you know, you do hit a ceiling in the situation where you have done all the work. You pretty much have gone as far as you can go. You're participating. You're getting sleep. Your mind is relaxed and coherent, and you're not hearing voices. You're not acting out. And if a stressor does come up to you, you are able to handle it. Where do you go from there? And we found out today. Right. We found out today where you do go from there. So I really had no idea how this all worked. It was pretty interesting. Aaron brought this up. So Morgan did cry and apologize to Payton in a hearing a while back. Aaron's looking for it. It was 6 years ago.
I never saw that.
So Aaron found it's a short. We can. All right. We'll look at that later. Let's. Thank you, Aaron, for that. We'll definitely pull that up later. So she apologizes. It's less than a minute. All right. We'll definitely pull that up later. But let's continue on just a little bit. So let's see. What else struck you? I'll look through my notes to see. I know there's a lot that
the
I
RAP plan. I wanted to explain what the RAP plan was, the Wellness Recovery Action Plan.
Okay.
I love those, and I was so glad to hear they did that. So it is it's like essential on these conditional releases, and they started back in the early or mid 90s, and for community and mental health, and what it was is like a relapse prevention / community care plan. So it used to be like a peer-led thing where like other clients who were in recovery from mental illness would help people establish these, other clients establish these. But so it's a whole plan of like, okay, here's my illness. This is what it means. These are the symptoms that happen in general. These are the symptoms that happen to me. Mm-hmm. If I'm having this symptom, this is what another person might see. It's a very detailed explanation of the course and presentation of that particular person's illness. And that's the first part. And it's used to give to other people so that others can help you be aware of your of what they might see and when they might need to intervene when you can't help yourself. So it's also lists all of your doctors, your therapists, how to contact them, who you would prefer someone to contact first. If you have to go to the hospital, what hospital do you want to go to? If you are in crisis, who do you want to be called on your behalf? These are the people I give permission to speak with X, Y, and Z. It's just an extremely detailed plan. Like if I'm in crisis, or if someone starts to see these things in me, this is how I want you to approach me. This is what you should tell me so I'll understand. Like it's great. It's awesome. So you're like planning ahead before a crisis happens. So that you're not totally just relying on yourself to be able to recognize when things are getting a little off. And so this plan would go to all her new therapists. It would go to any friends, family, anyone she's going to spend time with that she wants to give this to. So they read through it. And so if they see, if Morgan says one of her things is, I know I'm starting to get symptomatic when I'm only sleeping 3 hours a night. Well, whoever's monitoring the group home starts to see her getting up at 3 in the morning. They can see, that's in her plan, that she might be decompensating. They can alert the people that need to know, so they can keep an eye on her, figure out what's going on. So it's really good. So you aren't fly by the seat of your pants planning in the midst of a crisis.
Yeah, no, proactive,
I
definitely.
love those things.
Yeah, proactive
Yeah.
is definitely the way to go. Okay, so something I was just thinking about, Carly Gregg, Chloe Driver, Morgan. So because Morgan was offered the plea deal and she took it, I guess plea deals were not offered to Chloe, I'm not sure, and or Carly. So could they have said, look, I did this and I want to go guilty by reason of insanity? And if so, would they be in the same situation then as Morgan?
I feel like Carly might have been offered a plea deal, but I can't remember.
Yeah, I don't recall
if
right
she
now
did
either.
or not.
Yeah.
I don't know. No, I don't think, like, if you didn't initially plead insanity, I don't think you can go back and be like, wait a second. I mean,
I changed
you know
my
what
vote.
I mean?
Yeah.
Yeah, I don't.
But if they had, then they would be in the same situation. They would have been sentenced to an institution. They would have been able to work out whatever it is, and maybe at some point be released. Although the difference is Carly and Chloe did kill somebody, Morgan did not. So I guess that's the big difference.
Yeah,
That's the big difference. Yeah.
that is a big difference. But insanity shouldn't matter. It doesn't really matter what the crime is. If you were insane when you burglarized somewhere, you can still use the same defense. It's not,
Right.
Yeah.
Now, I know you were in our chat earlier, and there was a lot of comments flying. Is there anything that jumps out at you that you want to set the record straight? Did you take notes?
I did write a couple things down.
You were so such that you had to take notes.
I don't want to get worked up when people, I just want people to have the right information. Do you know what I mean? If your opinion's different, it's fine. But I get so no, I want people to know what the truth is, of the facts and everything. And so that's what gets me kind of fired up. It's no, they need to know.
Absolutely. Couldn't agree with you more. Yeah, couldn't agree with you more.
They need to know. So I wrote down about the faking and her lying and that kind of thing. I promise you that even before this happened, she was probably a very good liar. I don't think this is anything new that she's learned or whatever, and a lot of people in these situations are. If we said, I also think you have to take developmental factors into this too. She was 12.
Yeah.
Kids lie. You know what I mean? Honestly, she just kind of became not a kid, and also being able to understand the seriousness of things. That's such a developmental thing, And so it's not surprising to me that it's taken this long, and that just a year ago she was saying, oh, I never had symptoms or whatever. That seems like a maturity thing to me. And then once it was addressed with her and she was able to understand, oh my gosh, my puppy's an escape artist, right? Hold on a second. You better get back in there.
Oh boy. What happened?
She is, oh my God, I still have my earphones on. I just busted her trying to go through, we have a baby gate up, and I just busted her trying to squeeze herself underneath. Okay.
All right.
Anyway, sorry, but
It's okay.
I just think developmental factors are so important in this case. It's not surprising to me that she tried to do this lying thing, she got confronted on it, and she was able, the important thing is she's able to make that change. She's able to be okay, I need to just understand this better. And that's plenty of time, I think, 8 months to be able to work daily. And that's the thing too. Remember, she's in a facility where she's getting this every day. Right. It's not like us who would go once every 2 weeks to therapy. I would say, okay, well, 6 months probably isn't long enough. You know what I mean? It wasn't 10 sessions. It was 150 sessions,
Right.
So
yeah, well, I think just the fact that she is kind of she's taken responsibility just by acknowledging what she did. She was young when she did it. She is changing her story by. I think that alone is showing me that she's taking responsibility versus I'm just trying to work the system. You know, I think coming to grips with her assault by her father has a lot to do with what happened from her trying to hide and, you know, what caused this in the first place to escape. Having her mom support her on that obviously is huge. Hopefully her brother now is as well. I don't know if her brother is younger or older than her, but I'm sure her brother's saying, hey, sis, you know, I got your back now. That's probably huge for her. You know, so
Huge.
I think just the fact that she's acknowledging all of that shows me that she's taking responsibility for her life, and maybe to that end she can somehow make amends to Payton. I'm not sure how, but maybe just her everyday life will help make amends to Payton. If Payton will ever accept that. Payton may, and that's her right to never accept that, you know. So
Yeah. I doubt there will ever be contact allowed.
Yeah.
Between them. I think that will probably be a lifetime protective order.
Now, what if Payton says, hey, I do want to reach out to you 20 years from now? What if she's like, hey, you know what, dude, so, because Taylor brings this up and this is a really good point, will Morgan room with men now that she's identifying as a male? You know, what if...
I have no idea.
I know. What if some point, you know, Payton is like, you know, 20 years have gone by, I've got kids, you know, I've worked through my issues, or maybe she won't. I'm just, you know, speculating and, you know... But maybe, so if Payton wants to make contact, then she has the right to do that, right?
She can petition the court.
Yeah.
So she can, but then by her even, like if she were to show up at the group home where Morgan is, like Morgan violates.
Right.
Like Morgan still violates.
Yeah.
So Payton would need to petition the court.
Okay.
To lift it.
Right.
And you could petition the court to lift it under certain circumstances, like for brief time limited, you know, a time limited, like I'd like to meet with her this one time, supervised, blah, blah, blah. Will the court allow it? Like that kind of thing, if they wanted to talk about it. But the whole, like, you know what, the whole transitioning thing, like, I don't know if they are actually transitioning. Like, I don't know where they are in that process, but I will say it may be more difficult to find a group home for her, because my assumption is that they would probably put them in a single room.
That's what I would think. Yeah.
For now.
Yeah.
And a single room is going to be harder to find and place than having a roommate.
Gotcha.
So.
Yeah. Yeah, that's a very delicate situation, difficult situation. Where do you put somebody like that?
Unless there's another transgendered male that they are, you know, I mean, it could be that they could room together. I don't know exactly how. That's going to be state to state anyway, and group home to group home.
Yeah.
So.
In Waukesha, Wisconsin, how many transgender people are going to be in a state institution or going to a group home? Yeah, I mean, I would think that
I don't know.
That population is probably pretty small. The very first witness, which was called by the state, and I called this out at the beginning, I'm going to pat myself on the back. The one and only state witness, basically, as I'm going through it and listening to it, I'm like, you sound like you're for the defense. And then sure enough, the defense says, the one and only, well, he didn't say one and only, but he said the state's witness even said that she should be conditionally released. What do you make out of that? And as a prosecutor, like, just put yourself in that position. How do you combat that when your own witness is saying, yeah, she should be released, or they should be released?
Yeah, I think they were hoping. I think they didn't have a choice really, but to have her, that person testify. And I think that they were hoping to capitalize on the, you know, because risk factors were discussed and protective factors were discussed. And I think they were hoping to capitalize on the risk factors. Like, here's what could go wrong. You know, she's always going to be a risk of this X, Y, and Z.
Right.
And I think they knew she would talk about that at least, and how she came to the formulation, but like, and that people would get hooked on that rather than, or the judge would get hooked on that rather than the ultimate recommendation, if that makes sense.
It does, yeah. So Mandy brings up a good question. Romantic relationships, what if she, I would assume that's frowned upon in a group home situation. I would assume that you're not allowed. But what if she does connect with somebody outside and she develops feelings, or they develop feelings for somebody? How do they deal with that?
That's going to be group home specific. Some group homes do not allow visitors in private room, that kind of thing. Some of it's really going to depend on the group home. I imagine the first one she goes to, it's going to be a pretty strict, like, you don't bring boys and girls back here to do,
Right.
what, can you hear me?
I can. Yeah. Yeah. I can
Okay, my one AirPod decided to go down,
okay.
to fizz out. Yeah, so, other group homes, like, as it becomes more of like a independent living kind of situation where she's not necessarily monitored, they'll have different rules about visitors. If she meets somebody like on the outside during one of her Starbucks or library visits or whatever, it would probably just remain a public sort of thing. I mean, if she's not going to have the ability to communicate either, it's going to be really hard for Morgan to have a relationship for quite a long time.
Yeah, because one of the things that they kept talking about was that she has not had the ability to experience life. Having that first job,
Right.
being rejected, dealing with relationships within employment. But then add to that, how many people have met their significant other and or dated in work? Let's face it, you spend 40 plus hours in one place, you're going to develop, you're going to meet people. So that being said, how can they deny her that at some point, I would think at some point she should be allowed to explore that. I don't know when that point would be, but I would think at some point, because that is part of dealing with stressors, being rejected or, you hurt me, or, I mean, let's face it, that's a huge part. Yeah, it's a huge part of growing up and maturing and developing and evolving is interacting with people. So I would think at some point.
It will be a long time before she has the freedom to be able to actually develop a relationship.
Yeah, I agree. Let's see. Let me think if I have any. Let's see. If you want to pull out anything for yourself while I just kind of peruse my notes here. Yeah, that the experience fantasy became blurred with reality. I mean, I remember when I was 12, 13, 14, I was reading a lot of fantasy books, J.R. Tolkien, The Hobbit. I mean, I'd take walks in the woods thinking, I'm an elf and there's orcs over there. I mean, I was fantasizing all the time. So what is it that makes people, what is it that makes people cross that line,
So Morgan, number one, underlying mental illness. Number two, if she was being abused. Being abused by a parent in that way is so fracturing. Like this is the person who's supposed to love and care for me. Now they're taking on this other role. Like what's real? What's real and what's not. Also, just that desire to dissociate and escape, to perhaps even like act out the fantasy of, escaping that abuse or fighting against that abuse. I mean, it had to have been extremely scattering for her. On top of like, we don't know, was there unfettered access to material that she shouldn't have been looking at? It's a combination of things. And I think with underlying, mental health issues, whether that was being on the spectrum, having a psychotic disorder that was budding as a child, a combination of any of those things can just, it's not a normal kid with normal life experiences up until that point that ends up having this happen. So there's a level of dissociation that had to have been occurring for that. Like, she could not have been totally connected to reality for that to have occurred.
Yeah, I agree. Capri Law 12, I literally thought I was Harriet the Spy and walked to the graveyard every day. Yeah, I mean, I think it's kind of... it's
That's cute.
Isn't that like healthy to have an active imagination? I remember as a kid, that's like, you have an active imagination. That's great. I mean, it wasn't frowned upon. It was considered healthy and normal and,
It's unhealthy when you don't know the difference. I mean, if you really thought you were Harriet the Spy and trying to like dig up people's graves or something, I mean, that's a problem. Like, if you're pretending,
that is true.
Then that's good.
That is true. Yeah. That is true. So there's a few in the chat that I guess are new. Yes, or didn't hear that. Yes, the judge has granted Morgan conditional release, and she has 60, or her team has 60 days to come up with a plan But then he said February 14th, which is not 60 days. But I guess that's the initial. Did you catch that at all?
I didn't get to see it.
Okay, that's
all
right,
I heard
yeah.
was she was granted release. Yeah.
Yeah, first he said 60 days to review the plan, and I have Judge hacks up lung, and then February 14th needs conditional release plan. So maybe they have until the 14th to get together, but then they have 60 days to actually come up with the plan, because I'm assuming this just doesn't happen overnight. You have DHS, you've got social workers, you've got therapists, you've got how many people? 10, 5, like what?
Right.
How many?
And this is the government. I mean,
Yeah.
But that was one thing I was going to say is some people were asking about, like, well, if they don't have the details, and even the prosecution said that, if they don't have the details of what's going to happen on conditional release, then how can they grant it? Well, so some of these group homes and services aren't going to agree to take Morgan until they have a court order.
Right.
And so,
Yeah.
so they are actually stuck and can't find a place until that order comes out. And also it is a waste of resources if they are spending 40 hours a week trying to figure out where to place her, and then the judge says no. I mean, that is a
agree.
bad use of resources.
100% agree. Yeah, 100% agree. Yeah, that's what I believe it was the last Lisa Portman? I think she said, yeah, once the release is granted, then WCS finds a group home. Yeah, so they once the judge approves the release, meeting with all the resources. So yeah, absolutely, that would be a complete waste of time, because there's a chance.
Right, and they'd be holding a bed that someone else could get. That's just not how it works.
Makes no sense, yeah. All right. Let's see. Sam R. says, once she finds a job, I guess, or will there be one ready for her when she gets out? You want to tackle that one?
No, she's going to... So, I mean, it's going to be pretty basic for her. Like, it sounds like she needs to catch up on educational stuff. They aren't going to make her get a job right away. They're probably going to have to teach her. Like, I mean, think about it. Since she's 12, she's been in an institution. They're going to have to teach her, like, how do you complete a resume? How do you fill out an application? What are the steps you take? Like, there are a lot of life skills things that this group home is going to be working, and her treatment providers will be step by step walking her through. So she won't immediately have a job. Her immediate job is to stay in treatment.
Right.
That's what will be happening.
What even is a resume? Let alone, or what is an application? Yeah. What do I do with that? Yeah.
Right.
Yeah.
So she'll probably work with like vocational rehab, like another state department, vocational rehab, to help her with like finding a job, on the job training, probably that kind of thing, limited hours. Like it's going to need to get to the point where she can be unsupervised in the community for a certain number of hours also, because they can't have somebody sitting at her work staring at her. So like, that's going to have to be the next step. Yeah.
Right. And that's going to be probably, years from now. It's not going to be months. It's going to be years from now. What do you make of her wanting to be first an artist, then a published author, then substance abuse therapist, and then I think a librarian also? Do you think that that's too many choices for her, or because I talked about that?
I think what's important. Yeah, I think what's important is she's thinking about what she wants to be and wants to do, and my only thing was when they said, when they asked, are these realistic goals? I think being a counselor could have, I don't know what her, I know like juvenile records are sealed and stuff, but I don't know what her background check's going to look like. And being a counselor, and she'll have to get fingerprinted and background checked and all of that kind of stuff. I don't know, maybe if she moves to a different state eventually. I don't know that that's a short-term and short-term meaning 5-10 years. I don't think that's a realistic.
Yeah. And let's face it, that's a lot of schooling. That's a lot of schooling to be an artist, or
a lot of schooling,
or a publisher or an author. Quite honestly, you don't need any schooling for that. But yeah, to be a therapist or a librarian, I think a librarian, I'm sure you need a lot of schooling as well. You just can't become a librarian.
Yeah, she could work at a library. I mean, she could work maybe even front desk at a counseling center. You know what I mean? I just think it's going to be, I think that's pretty lofty to think in the next 10 years you'd be a counselor working to help other people. But, I think it's important that she is planning and looking at options, and that's good. I mean, if she was like, I'm going to be an astronaut, then I might be like,
Right. I commend her wanting to help. I commend her wanting to help. If she wants to be a therapist, substance abuse, I commend her for wanting to help people, to give back to society. Being an artist and an author, as well as, that's giving back to society as well, so.
Yeah, definitely. I mean, I wanted to be an archaeologist at one point in my life.
I remember when I was like 5 or 6, I wanted to be everything. Literally, I wanted to be an oceanographer.
Yeah.
I wanted to be an astronaut. I wanted to be all the stuff. And my brother popped my bubble, burst my bubble. He was like 8 years older than me. He's like, Chris, you can't do all that. I'm like, meh.
Aw.
Yep.
I be whatever you want.
You have to choose just one.
Yeah. Well, I also imagine she's probably developmentally a little younger, emotionally and psychologically because of being institutionalized. So,
That's okay. That's a great question. So she gets out and she starts to go to school. She's 24. Does she go to community college? Does she go to high school? Like, what does she do?
She'll go to adult high school. I mean, there's adult night school. There's adult high school. There's a lot of online high school diploma programs.
That's true.
I'm sure she'll do one of those. She won't go to actual school. But then college, eventually she can go to wherever.
Right, because that's part of her integration is to socialize, right? It wouldn't be just to stay online. It would be to get out into the world and socialize with people. But she would still be 30 or 35 when she's going to college, which may be some kind of weird stigma, but a lot of people are in their 30s or 40s and they go back to school or they go to school.
Yeah.
So.
Well, and if her program is good, if her group home is good, they will be creating situations and scenarios for her to be able to socialize in the community and with other people her age. Like they will find things, help her find things to become involved in. Like if the library is something she's interested in, they'll take her to the library. She can see what programs are going on there. She can maybe even attend some while somebody else is kind of in the library looking out for her.
Right.
They'll figure all that out.
Right. Okay, let's see. Chat, do you have any?
Hungry.
Yeah, well, she just came in. I think Aaron just let her in. Chat, now's the time to ask questions.
Yeah, because I got to eat dinner here in a little bit.
While we have Dr. Rachel, we'll get a couple more questions before we let you go. Trying to think of, let's see, do I have any questions or any things? Let's see, slight deviation. So do you think, okay, my question, did you have a chance to answer any of the polls? Has the state met the burden to release Morgan? Did you answer that? Yes, no, or you want to order pizza?
I didn't see that one. I don't think they met their burden to keep her in. No. I mean, they had one witness. I think they knew it. They just had to be there.
Just had to do it, yeah. So, 46% said they did not. But then the other question was, should she be conditionally released? And I thought that was more of an emotional question versus has the state met the burden. So should she be conditionally released? What do you think? Yes, no, or not sure?
Yeah, I think so. I think that she's met her cap there. Like, I think this conditional release is still very strict and she still will be required. Like, there will be so many eyes on her. Like, she's not going to be able to decompensate to the point where she's a danger before they send her back. Like she's going to be very well monitored. And I think you guys, like, this is a good thing. Like she could rehabilitate. Like this is a great thing that at so young, she's worked this hard, to get to where she is right now. And I mean, 0 violent incidents other than the one suicide attempt, but as far as toward other people, 0 violent incidents. I mean, that's significant to me. And lots happened. Like she's lived her whole childhood there, her whole adolescence there so far. And this is a good thing that, this program worked for her. And I think that's awesome. Like, imagine if she would have gone to juvie and then she would have gone to adult prison. Like, she would not be the person she is right now.
Yeah.
They would not be saying these things about her.
Yeah.
So,
and only time will tell if which path she's going to choose. Is she going to go on and invent the next penicillin or be the first woman on Mars? We don't know. Or will she go and off 20 people in some grocery store? We don't know which path she's going to take. We hope it's going to be something positive and to give back to society. We hope that. Right. But some people in the chat were like, basically lock her up, throw away the key. And it's like, that's well and good. That's your opinion. We respect that. But you're not giving her the opportunity to go out and create the next book, the best-selling book. She could be the next Harry Potter, next J.K., and you just never know.
But I think, I think some people don't want to see people like her succeed. I mean, let's
Yeah.
be real. Like, and I'm not knocking anybody in the chat specifically or whatever, but I do think as in the public, in general public, like, we don't, like, what right does she have to have success in life? You know, I think that
Right.
can be a thought sometime, but
I agree. All right, let's get to MLC's question. What is the extent of her patient rights as far as medications?
very good question. So I can tell you this, if her doctor says it is too risky for you to not take this, and she still refuses, she's going back to the hospital.
Okay.
She can always say, hey, like, I would like to try to wean off of this, and the doctor can agree or disagree, and they can monitor her for it, and you know, they can do things like that, but it's always going to have to be with her doctor's agreement. So yeah, she will be as part of her conditional release, following doctor orders, is going to be in there, and that includes medication.
Gotcha. All right, we're going to go through just a couple of quick questions and we'll let you go.
Okay.
Mandy Strong, please discuss psych and neurology being under the same board.
Oh, so that doesn't mean that a psychiatrist can practice as a neurologist and a neurologist will practice as a psychiatrist. They just join them together because psychiatrists still get the training in brain and spinal cord and nervous system. Like, they still get that training. It's just that their residencies are typically in one or the other. So like, you have to understand the whole brain, both like chemically and structurally, like, in order to be both. Like, there's just so much overlap there. Like, a psychiatrist would never go do brain surgery like a neurologist would. Do you know what I mean? Like, they know their lanes, but the board information is all the same. They both have to know about each other's stuff. They just don't specialize in both.
Gotcha.
That makes sense. And there are neurologists who treat like ADHD, some of the more cognitive related disorders, like ADHD and some of the like developmental disorder issues, traumatic brain injury. A lot of times neurologists will prescribe, you know, people with Tourette's, tic disorder. A neurologist can absolutely handle those. So can a psychiatrist, but you know, sometimes you seek neurology for that.
Gotcha. All right. Baca of 3, this is a good one. Does she have to, because I want to ask this as well, does she have to disclose legally her offense or to any potential employer or higher learning? Like, will she be put on a register? Does she have to register?
There won't be a registry. I think it's all going to depend on what is accessible through her. Like, she'll need to know, and I don't know. That's what I was trying to find out from my attorney friend. They haven't responded yet, but I don't know if there's going to be something on their record, then yes, they need to disclose that.
Okay.
I don't know how applications are if they say you've been convicted of a felony over the age of 18, or because I don't think you have to report your juvenile record. So, and I don't know if hers, because of it's such a long like sentence, I don't know if it's that's considered like it just turns into an adult record after that. That's all like really state specific, so I'm not sure about that. That's a very good question though.
Yeah. Bab says, do you believe that there's ever an instance where someone that young should get a life sentence, or should there be more of a focus on rehabilitation?
Personal opinion, I do not think that anyone who is under 18 should be given a life sentence without the possibility of some kind of release at some point.
Okay.
Given proof of rehabilitation.
Right. I would love to talk to Florida PI Sam about that, because she says she's been dealing with kids offing kids like way too often these days. So I'd like to get her opinion on that. 14-year-olds, you know, offing other 14-year-olds, you know.
Can't even imagine.
This is good. Young black economist. There's a guy who ended his entire family when he was 15. He eventually became a professor. There you go. All right. We will let you go unless you want to continue on. It's up to you.
I think that's it. I just hope
Okay.
that I answered everything.
Yeah.
Let's see. I see. Yeah, mental health court is not available everywhere. That's correct.
Where is that?
We don't know about her record. So like mental health court is like not typically for these kinds of cases either. Mental health court is like lesser crimes usually, and like first offense kind of stuff. And it's basically just your sentence. Like you can, if you fulfill the requirements of the court, like probation or and your mental health care, and then there's like proof to the court that you've been attending mental health care, taking medication, blah blah blah, then like you can get your record expunged after that kind of thing. Like they have just different provisions for mental health court.
Okay. Everybody
Just
loves
scrolling
you.
through if there's anything. Oh, I love everybody. I mean, most of you. I love our chat. So.
Our chat is the best, yes.
It is the best, even when you yell at us. Oh, the puzzle story. Let me talk to pre-law the puzzle story.
Okay.
Speaking of, and also I want to make it clear when I threw stuff, I didn't throw stuff at the dog. I just threw it into the foyer to make the noise to startle her in the other room.
Okay, puzzle story.
I wasn't abusing my dog.
Okay.
Puzzle story. So we have this dog. She's not even a year old yet. My husband and I got a 1,000-piece puzzle, not even 1,500-piece puzzle to do before the holidays. And we started doing whatever. We were trying to be really careful because as soon as a piece hits the floor, I mean, she's quick, right? She comes to get it, whatever.
Yeah.
So we're putting the puzzle together. It was like the first 5 minutes. My husband looks over and he's like, "What does she have in her mouth?" And it was like this. You couldn't even tell what it was. It was just like this gummy mess of whatever. We were like, "Is that a puzzle piece?" Like we couldn't even tell. I'm like, "I don't even think it is." But we like put it aside. We finished the puzzle, and yes, there was one missing piece. So we took the ball of mush and we stuck it in there.
Nice.
I hate that when there's a piece missing and we took a picture of it.
That's hilarious.
So that's my puzzle story. I feel your pain.
What was the puzzle?
Right.
What was it? Do you remember?
What was the puzzle of? Oh, it was one of those like it was like landmarks of the United States, like all like collage of landmarks of the United States. Yeah.
That's hilarious. And there is the puzzle story, Pammy.
Yes.
Awesome.
Yes.
All right. Well, we'll let you go on that. Thank you so much for joining.
You're
really
welcome.
enjoy your
Love you
insight
guys.
and always please next time we have another case like this or anything like that, you're always welcome, and I hope that you come on again.
Sydney Powell was granted her retrial. You guys need to look that up.
Okay.
And one of my colleague friends is actually one of the experts on there, and it will be live streamed. So we will have
fantastic.
To
We will definitely cover that for sure. We will cover that. Fantastic. All right.
Cool.
Well, have a good night. And
all right, guys.
Thank you.
See you. Good night.
Okay. Bye.
All right, bye.
All right, guys. That is all we have for you today. So thank you for joining us. I'm going to say goodbye. We got kitties. We got two cats. We got a showdown going on between Rafa, Paldi. All right. Thank you guys for joining us. We are going to pick back up on Florida versus Segura. Oh, great. Aaron has scheduled the Henry Segura. We're going to pick up on day 2. I'm hoping I can maybe get through day 2 and day 3. We'll see. What time did you schedule that for? 9 o'clock. All right, so 9 o'clock tomorrow, 9 o'clock Eastern. We're going to pick back up on Henry Segura. Then there's a new trial starting in South Carolina next week, so I want to pick up on that. So I'm hoping I can get through Segura. May not be able to because there's like 6 days, I think, 6 or 7 days. So I'm going to try. We're going to try to get through him. If we have to put him on pause, I'd rather do a live trial and we can go back to Segura. The video, yes, beautiful waterfall. Thank you for reminding us. All right, let me pull that up. What about the video? Yes, see, beautiful waterfall. That's why we have people like you in our chat, to remind people like me that there's a video to watch. All right, let's get to this. Okay. All right, let me put myself down. Turn off that. All right, so this is the video of Morgan apologizing. Okay, so this is Morgan apologizing, you guys. me just rewind this a little bit. Now let's check it out.
I just want to let Bella and her family know I'm sorry. I never meant this to happen. And I hope that she's doing well.
All right, thank you. I appreciate your comments. Anything further than from Ms. Geyser's?
All right, so there was her saying how sorry she is. So let's we'll take it for what it is. You know, seems like she's pretty distraught there. So all right, guys, with that, I'm going to say goodbye, good night, so long. Thank you to Aaron. Thank you to all of our fantastic mods. We'll start with Rachel B because she was on our came on. And thank you to Julie and OnlyFan. Thank you to Therapist You Know. Thank you to Brat. Thank you to Florida PI Sam. And thank you to you guys for being with us on both streams, part 1 and part 2. Appreciate you coming back and being with us. Join us tomorrow. We're going to pick up on Florida versus Henry Segura. That is, if you're not familiar with that one, that is a man who was accused in 2010 of offing his girlfriend and 3 kids. One of them was his. He went to trial in 2017. It was considered a mistrial, and then we're going to watch the one from 2019. So, yeah. So thanks, guys. Thanks for joining us, and appreciate you. And we will see you tomorrow, hopefully. And if not, hopefully you'll catch us somewhere down the road. So with that, I'm going to... We don't have the outro. Hold on. Is it here?
It's okay.
Yeah, we won't play the outro video. Is it over here? No. Okay. Guys, thanks for joining us. We'll see you tomorrow. Appreciate you, and have a good night. Bye.